Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we're talking about sovereign citizens, which are known to all the lands of the world. And we are reviewing a Canadian case in particular. This is the case of Meads versus Meads, which is well known in law circles because it was one of the best and most thorough explanations that's ever been done trying to explain the sovereign citizen phenomena. This is just a divorce case. There's nothing particularly special about the case in particular, but the judge went to quite a lot of effort to explain the sovereign citizen phenomena. And so we are going to review this discussion because it is a good review of the subject. And we're going to go through this in some detail. This is a fairly lengthy opinion. We're going to be here for a little bit, so strap in, guys. Let's go ahead and get started. So we pick up after the initial discussion of the case itself, because as I mentioned, this is a divorce case. So the first 30 pages or so are kind of dealing with, the actual subject matter of the actual case, which isn't what concerns us, right? Our concern is the sovereign citizen crap, which this court uses the term OPCA, which means organized pseudo-legal commercial argument. That's pretty cool too. Organized pseudo-legal commercial argument. Okie doke. So we're going to learn about the organized pseudo-legal commercial argument, sovereign citizens, arose by any other name, right? All those things. Okay, great. So first of all, let's discuss who these people are. Who are the organized pseudo-legal commercial litigants? Well, in this court's experience, there are no stereotypical litigants. They may be of any age or gender. Some are affluent, others are not. Canadian case law reports concepts advanced by professionals, blue-collar workers, business persons, and retired individuals. Some travels in groups, while others appear to operate by themselves. The court has observed that some litigants appear to suffer from cognitive or psychological disorders. However, one should not presume those conditions from the presence of the arguments and concepts. So some of them are a little bit wrong in the head, but not all. Similarly, bizarre in-court conduct does not necessarily mean these people suffer from that kind of disorder. Anomalous behavior may instead reflect the rules of strategy and script, right? So it could be due to mental infirmity, but it could also be by choice, right? A person could be putting on an act, putting on a show, right? So yeah, just because a person acts a certain way or just because a person acts crazy doesn't mean that they are crazy. So much like Darrell Brooks, right? He doesn't really seem to suffer any problems, and we saw that through and through repeatedly because he wasn't doing a very good job of maintaining the act. The act dropped because of his own narcissism. He wanted to make sure that he proved to everyone how smart he is, which he did. But yeah, so basically, sovereign citizens come in all shapes and sizes and all kinds of backgrounds. The motivation to adopt this approach varies. Certain litigants are clearly undergoing some kind of stress, so some of them are doing it out of desperation. Foreclosure, and then they refer to some cases where this kind of tactic has been done in Canada. Foreclosure on a home, bankruptcy, disputes over child and spousal support, deportation in response to large debts. Those were the cases the Canadian court highlighted. We do see this in traffic cases. I've never really seen it anywhere near this level in terms of like a murder case. So in that respect, Darrell Brooks probably is in a league of his own. But it's not unusual that a person in extreme distress looking for their last grasp of hope, right? Other times, of course, the litigant may be linked to some distressing event, such as a parent losing custody of a child. Other times, they're simply scammers. Some of them really don't believe what they're selling. They're just selling and looking for a sucker to buy. A substantial amount of litigation seems to revolve on comparative trivialities, such as parking tickets. This is very true in the United States as well, too. This is where you're most likely to see it. Litigants sometimes call themselves students of the law. I've never heard that particular expression in the United States. Please don't ever use it. This is a sham. Their interest goes no further than finding a proverbial gotcha exception or loophole they can spring to defeat state and court authority. They are no students of the law. Please don't ever call yourselves that. It's an insult to those of us who, actually study this stuff. Courts have commonly rejected claims by these litigants that their actions were in good faith or innocent. Again, some people might claim that they're acting in good faith. People might claim they're innocent. They might claim they don't understand. There's a difference between ability and willingness. Competency goes to your ability, not your willingness. So sometimes people are liars. Amazing. A particular case provides a good example. The reason for that result is illustrated in the review of that case of evidence that led him to dismiss a dentist's claims she had a reasonable basis. So some dentist was using this argument in some case. Let's see if dentist arguments look at all similar to Brooks's arguments. As tax seminars, most of the lecturers use aliases as opposed to real names. She did not regard this as suspicious or unusual, even though one of the lecturers went by the alias Sir Larry Loophole. How could an intelligent, well-educated, worldly 39-year-old professional not be suspicious? At the beginning of each of the 5 lectures presented by Mr. Porsky, who I suppose is Mr. Loophole, the following caution was given. In no way should this be construed as either legal or financial advice. You should consult a competent expert. Yeah. Mr. Porsky frankly told the attendees at his lectures, I'm in the building trade. I'm not a lawyer. I can't give you legal advice. I'm not an accountant. I can't give you accounting or financial advice. I'm just a guy banging nails. He also said, I strongly recommend you consult a competent expert on the subject matter. Yeah. Okay. Dr. Siddell knew each and every lecturer, I suppose this is the dentist, Dr. Siddell knew each and every lecturer was not a tax lawyer or tax accountant. Every lecturer was upfront about their lack of accreditation. Nevertheless, they talked about law, the statutes, interpretation, and statuses. They discussed court cases and reported court judgments. Dr. Siddell accepted their views as experts who were imparting accurate information and opinions as to what Canadian law was. She said that she could not recall if she questioned any of the lecturers during the seminar. She said she didn't research any court cases they referred to. She did not go online or to a law library. She told them that they were decided and reported on legal cases throughout Canada relating to issues under discussion. To not have read any of these cases for herself, or even as much asked the lecturers for copies of the cases, is evidence of willful blindness. Yeah, I mean, yeah. Dr. Seidel asked her father to attend one of the tax lectures with her. He walked out in the middle of the lecture. She testified she didn't ask him why. She did say, though, that her father and her sister became estranged as a result of her disagreements over the view of taxation. Dr. Ingeman testified that he had told Dr. Siddell on more than one occasion he thought she was going to be brainwashed by a bunch of losers who don't work. These were the 2 or 3 key people in her life, and yet, contrary to views that did not cause her to seek some independent tax advice. It's going great over here. The judge continues by saying, this does not appear to be atypical. The judge says this court routinely encounter litigants who seem quite willing to pull the wool over their own eyes. This is pretty bad, guys. If the guy is saying, hi, my name is Larry Loophole, I am not a lawyer, I am not an accountant, I am not a professional, I can't give you legal advice, I can't give you accounting advice. Moving on, let me tell you why you don't have to pay taxes. Guys, dude, that's on you, man. I mean, come on. But apparently there are people who are medical professionals, in this case a dentist, who are willing to just ignore things. It's sad. Anyways, continuing on, what is crucial is to understand that these litigants in court is likely operating under instructions obtained from commercial sources and being told to conduct and frame their court activities in an unnatural, incorrect and distorted context. The litigant is instructed to follow script that is, in all probability, illogical and certainly contrary to law. The litigant may not be able to explain his or her actions for the very same reason the judge is confused by the documents, submission, and in-court conduct they provide. Neither really understands what's going on, but for different reasons. Yeah. All right, so that's a little bit about who these people are. They come in all shapes and sizes. All right, so let's talk about the movements, because sovereign citizens come in some different flavors. Let's talk about some of these flavors. The movement, the community, includes a number of subsets. Each of these movements include persons who have adopted similar alternate histories and generally compatible beliefs. So they come at it from different perspectives, but kind of all wind up in the same place. Different movements may use instances and may use exactly the same strategies. So there's overlap. Members of the movement will often attend one another court's appearances. They appear to engage in considerable lateral discourse and often just seem to be, at minimum, social acquaintances. They run in each other's circles despite whatever differences there is. How nice. All right, so let's talk about one of them. The detaxers. We definitely have this in the U.S. too. People who don't think they have to pay taxes. The sovereign citizens don't think that they have to pay taxes. Yeah. The first of the no tax people in Canada were these no tax people. These litigants focused almost entirely on avoiding income tax. The detaxer movement has enjoyed a wide variety of assortment of strategies over the past, all without success. Lindsay, in particular, appears to have been an innovator and source of many of these strategies. Lagaman and Warman's theories demonstrate how the detaxers may have either left-wing or right-wing leanings. It crosses the political aisle. In recent years, this court has observed fewer true detaxers, no doubt in part to financial failure of Lindsay in many court actions and ongoing prosecution. This is also true in the United States. They still exist, but many of their gurus have gone to jail for, the tax evasion. So, they definitely haven't disappeared, but it's not the movement maybe it once was. Many of these people were professional or business persons with substantial income. Meads, the guy who's, the titular character of our case, appears to share the characteristic from the data before the court. Other Canadian movements seem to engage from lower income and occupational and employment context. Freemen on the land. How exciting. The Freemen on the land people. The Freemen on the land people are a comparatively newer movement, at least in Canada. From reported case law, individuals who self-identify with this movement appear active across Canada. Their membership is focused strongly on anti-government and has libertarian and right-wing overtones. Christian rhetoric is common. Mernard is a guru in this movement. It appears that freemen are a Canadian innovation, which I understand has spread to other common law jurisdictions, including the UK, Australia, and New Zealand. I didn't know that. The freemen on the land started in Canada? Canada's responsible for this bullshit? Well, thanks, Canada, for that wonderful contribution to our shared collective legal history. That's great, guys. Thanks. That's great. Okay, so apparently we're blaming Canada now. More to the point, a Canadian judge is blaming Canada, so, that's fine. I am unclear whether Canada has returned the favor and this group has established itself south of the 49 parallel. They definitely have. At least now. Yeah, but okay. Yeah. Stated simply, freemen on the land believe they can opt out of societal obligations. A common theme in freemen arguments is the state and court action requires the target's consent. Alarmingly, certain members of freemen on the land movement believe they have unrestricted right to possess and use firearms. That has led to at least one instance of freemen on the land being found with a concealed unauthorized handgun. Freemen on the land threaten to use a weapon on law enforcement. And that in many other ways, freemen on the land parallel American sovereign man community, Both engage in a broad range of sovereign citizen activity directed toward almost any government or social obligation. Both habitually use fee schedules and advance claims and liens against state, police, and court actors. Yeah, those are fun people. They don't believe that they're subject to the state, but they have no problems filing liens that are just crap against like everyone. But they do a lot of them, and it's a pain in the ass. Yeah. Both habitually use these fee schedules and advance claims and liens against state, police, and court actors. Many apply the everything as a contract approach and are so extremely uncooperative in and out of court. That sounds a little familiar. Sovereign man or sovereign citizens. The sovereign man, sovereign citizen movement is the chief U.S. community. Several reported Ontario decisions document court interactions with self-identified sovereign mans. This court has a limited exposure to sovereign men, most notably having been a lawsuit advanced by Glenn Wyndham, usually self-styled as Glenn Wyndham House of Fern. He calls himself Glenn Wyndham House of Fern. Okay. I was a defendant in this action. The judge was, that's cute. Along with Canada, Alberta, many police officers, the Prime Minister, governmental ministers, the Lieutenant and Governor Generals, and the Alberta Queen of Courts Bench, Chief Justice Whitman. The alleged actions broad conspiracy and misconduct by Canadian state actors. A chief complaint by Wyndham, who is a self-declared member of Republic of Texas. Don't bring that shit. Don't bring my state into this bullshit. Is that Canada Customs have refused to admit him into Canada with his firearms. This was followed up by a number of confirmations with Lethbridge area police officers, particularly traffic stops. Wyndham's documents claims he's not subject to Canadian law on the everything is a contract and courts apply Admiralty law bases. He also claimed governments are only corporations. The allegations and rhetoric in his court submissions express a perspective that's alarming. Let's read some of the House of Fern's court submissions. I have tried to use administrative procedures against these criminals, but they don't get the message. So this is the message. If they want to perjure their oaths of office and engage in treason and sedition and breach of trust and other crimes too numerous to list against me, they had better be prepared to go all the way and murder me as well, because by the time I'm done with them, I will do it all within the law. They will wish they had murdered me. My patriotic duty is to come after them, my last dying breath, and I will file commercial liens against them. I will liquidate their bonds. I will file criminal complaints against them and their bosses. I will seize their assets, and I will not rest until I see them do that little dance they do at the end of the common law rope. Yikes. And even then, in the next life, I'll be demanding justice before judgment bar, all caps, of God. I don't even want to know what the bar, all caps, of God is. Is that a thing? Wow, I don't even want to know. To make sure that they get to spend the rest of their life, eternity, receiving their just reward. Also, after I'm dead and gone on to the next life, because this is on the record, there's that record we all know and love from the last couple days, am I right? Because this is on the record, these criminals will be hunted down, just like the Nazi war criminals that are still hunted down to this day. And we end by God winning the entire argument. Just how special is that? Fun and exciting. That is a whole, yeah, I'm with you in chat, Dio. This is a whole new version of the Navy SEAL copy-pasta. This is, yeah, wow, this is, okay. Continuing on. Oh, well, there's more. Furthermore, these criminals are hereby put on notice that with criminals like them in this world, I have a death wish because this world is not big enough for both of us. So go ahead and make my day. The sooner I'm out of here, the better. And I shall exercise my God-given right to resist their unlawful arrest with lethal force, if necessary. And then they will have an excuse to murder me. So go ahead, criminals, make my day. That's a lot. Don't go sovereign citizen, folks. The judge, writing for himself, now says, my part in the conspiracy was to shove foreign martial law jurisdiction down the throats of all the people as an excuse to bring out my martial law shock troops and really kick some ass. This would alienate the populace from the Queen and trigger a coup d'etat. Wow, Judge, you are an important figure, it seems. Okay. Langston J, that's Judge, by the way, J. Langston J, that means Judge Langston, struck down Wingham's actions on, among other things, the defendant had acted in various nefarious and treasonous ways and refused Wingham's denial for $1 billion in damages. American courts have similarly rejected Wingham's claims. His action in Wingham versus Shulman, District of Columbia, oh joy, was dismissed as being a complaint that describes fantastic or delusionist scenarios, is subject to immediate dismissal. Moreover, a complaint may deem frivolous when it lacks an arguable basis in law and fact. The complaint appears to lack an arguable basis either in law or fact and may reflect delusional thinking. Accordingly, the complaint will be dismissed. The District of Columbia is also not really enjoying the musings of Mr. Wingham. Wingham's perspective of state oppression and violent focus seem representative of the sovereign man movement. In the United States, sovereign men are notorious for their violent conduct, intimidation of state and court personnel, and their misuse of legal processes to engage in paper terrorism. Here they basically mean those liens I referred to, by filing all these really, really false liens against people, because those liens, while crap, take a little bit of effort to remove. And so, you know, they can use the legal process in some respect to harass people. So that's what they're talking about. The FBI classifies sovereign men as domestic terrorist movement. I think so, yeah. A court that encounters what appears to be a genuine sovereign citizen may wish to take additional security precautions. Yeah, the sovereign citizens are a whole bunch of fun on every possible level. But they are not the end of the road. Let us learn more about these movements in their several varieties by turning our attention to the Church of the Ecumenical Redemption International. Okay, the Church of the Ecumenical Redemption International is in Edmonton area. Isn't that where Ian is from? Isn't Ian from Edmonton? Runkle, tell me more about your church. What did you do? Is an Edmonton area OPCA group apparently headed by Ballinger. The court has extensive exposure to CERI and its members. First and foremost, CERI is a pot church. Like the pot churches reported in other cases, Ballinger and CERI claim that marijuana is a linchpin element of Christian religions, and its use is mandated by the Bible, specifically the King James Bible. CERI membership otherwise appears to hold left-wing and anti-capitalist views. Most members seem to be on low income. Well, this case was written in 2012, so since then, marijuana has become legal in Canada, so I suppose they can have all the pot-related worship they want now, so yay. Some CERI members were involved in an earlier unsuccessful attempt to claim religious right to use marijuana. At that point, they defended themselves as Reformed Druids. These are not the Druids you're looking for? Because we're Reformed Druids? See what I did there? See, okay. Yeah. All right. Anyways, in present CERI membership could classify James Bible literists. This court may therefore have been witness to the cusp of transformation or conversion of CERI from faith to faith as the Reformed Druids interpreted Exodus 30:23 as the basis for their claim. Okay, what is Exodus 30:23? Hold on. Okay, what is this bullshit? Take thou also unto thee principal spices of pure myrrh, 500 shekels, and of sweet cinnamon, half so much, even 250 shekels, and of sweet calamus, 250 shekels. Okay, that's great. Fine. CERI members generally reject state and court authority. Many of the CERI's arguments have religion trappings. CERI members have been exonerated in all manners of proceedings. CERI members have adopted their everything as a contract concept and frequently argue magic hat. Dude, do they get magic hats? Dude, if they get magic hats, I want in. Runkle, where's my magic hat? For example, CERI membership has recently in Alberta Provincial Court argued that her car was not subject to motor vehicle legislation because it's an ecclesiastical pursuit chariot. I have to admit that's a first. Ecclesiastical pursuit chariot. Okay. CERI members subscribe to the double split person concept, but also attempt to detach themselves from their associated corporate entity. Documents filed by CERI associated litigants are unusually haphazard, even by these standards. Wow. So the Runkle religion over here, apparently their litigation is so haphazard, it qualifies as haphazard even by sovereign citizen standards. That's a whole new level, man. In most instances, they're clearly cut and paste assemblies of other parent documents. CERI membership is in frequent conflict with the police, judges, and government officials. They file private criminal offenses, informations for obstructing or violence or to arrest officiating clergymen. CERI members have at least some contact with Wynnum. Oh, that guy from earlier, that's great. CERI members witnessed his court materials. I've discussed how Ballinger and several other CERI members recently attempted to disrupt a family-oriented public education in the courts. Guys, this is just like so messed up. I mean, dude. Like, you know, it's amazing people buy this. It's amazing people who are well educated buying this. I guess if someone's desperate enough, you know, they'll believe anything. But man, wow. Moorish law. This is a fun one. The Moorish people, they believe that they're Moors or something. Yeah, they're a fun group too. Edmonton is home to Sean Henry, typically styled Chief, Nanya Shabu, L, of the Atsikhata Nation of Yamasee Moors, or less commonly, Sean Henry Bay. One of Canada's few Moorish law litigants. He's frequently appeared in court. The exotic nature of the Moorish law movement and its claims warrant some comment, as casual exposure to a Moorish law litigant may lead an observer to suspect mental impairment or disorder. The Moorish law community is predominantly an American offshoot of urban black Muslim churches, such as the Nation of Islam. They claim that black Muslims who self-identify as Moors are not subject to state or court authority because they're governed by separate law or are the original inhabitants of North and South America. The black Muslims are the original inhabitants of North and South America. Well, this is exciting news I was unaware of. I was under the impression that the original inhabitants of North and South America walked over here from Asia during the Ice Age, when there was a land bridge between Asia and the United States. But apparently I was wrong, and it was the Black Moors the entire time. Fine. The exotic nature of the Moorish law movement and its claims warrant some comment, as casual exposure to Moorish law litigant may lead an observer to suspect mental impairment or disorder. Yes. In the case of Henry, he claims that the Atsik Hata Nation owns North America, now renamed. North America's been renamed, guys. So strike out North America, read in Otland, Exim, Turtle Island, land of frogs. What? As a result of his treaty with the Olmi people, an early culture that existed in Mesoamerica from 1500 to 400 BC and are noted for their large sculptures of human heads. What? Justice Sanderman of our court, who has reviewed the documentary foundation of Henry's many claims, observe, it would be an affront to the dignity of this court and an affront to the dignity of any court to allow a document such as this to stand and force individuals to come to court to have to answer this, as I say, just absolute gibberish. Okay. Henry claims his ownership of Canada. Henry claims to own Canada. I suppose, yes, because Canada is in North America, or is it? I don't know. Because, you know, I don't know how the sovereign citizen parses geography. Is Canada part of North America? I honestly don't have a clue. Is the United States part of North America? What is a North America? If you have found a North America, please turn it into the lost and found so that it can be reclaimed by its owner. Henry claims to ownership of Canada renders him immune to court and state action, but also applies many other strategies such as magic hats, foisted unilateral agreements, and a variant on the A4V, money for nothing concept. Money for nothing and checks for free. I want my MTV. All right. Henry apparently spent some time in the United States and attempted to apply this concept. So great. In the Fourth Circuit, confirming conviction of Henry for false claims of diplomatic status and rejecting Henry's argument that because he had claimed to be a diplomat from a non-existent state of Otland, he could not have committed the offense. Though it seems unlikely to many readers, Henry is not alone in his peculiar beliefs. Sadly, no. Sadly, these beliefs do spread, friends. The insanity knows no bounds. These people, unfortunately, are not alone. There are people who subscribe to their newsletters. Yeah. In an action regarding a deportation order of the Immigration and Refugee Board of Canada, Immigration Appeal Division, describes the litigant materials thusly. The attached 7 pages consist of a color photocopy of what purports to be the Moorish American nationality card of a certain L.F. Hafas Hassan Hetep Bey. At page 1, pages 2 through 7 purport to be judicial notice and proclamation signed by L.F. Hassan Hetep Bey in 2010, which makes certain claims to title, rights, and privileges on the basis of his being a noble of the Al-Moroccan Empire. Written in legalese and citing various statutes to the United States, international treaties, and covenants, and extensively covers U.S. law. The document purports to deny the jurisdiction of the governments of the Americas over the members of the Al-Moroccan Empire, and in particular, El-Afif Hassan Hetep Bey, and establish him and other members as sovereign entities. The decision at paragraphs 14 through 18 reviews other documents received, including a writ of right consisting notice of default judgment, rejection of the Immigration Appeal Division as not authorized by American law. Well, he's got that one right. The Immigration Appeal Division is in fact not authorized by American law because it's Canadian. And claim of right, appellate name correction pursuant to Indigenous nationality and Aboriginal citizenship, whereby Kerba Kali Nicholas Shackles renounced in name in favor of his current name, El-Afif Hassan Hetep Bey. Okay, the litigant was ordered deported and subsequent appeal was denied. The board concluded now a reasonable person viewing various documents submitted by applicant in the name of El-Afif Hassan Hetep Bey could reasonably be expected to conclude he was mad and delusional. However, reading from these documents is abundantly clear to the panel. The appellant is not mad, although he might be self-delusional. Rather, the appellant is apparently making a political statement. Again, your ability to understand and your willingness to understand are 2 different propositions. He is not crazy. He is just self-deluded, which is not the same thing. All right. So wrapping up the movement section, there are likely additional movements in Canada other than those identified. Some may be local, such as CERI, and therefore unknown to the Alberta courts. Others may be below the radar. Members of this court report to me they've encountered a significant number of litigants who do not self-identify with known movements, or who, like Mr. Meads, do not have a known guru. Other movements will probably emerge over time. It is useful for a judge to know these litigants is associated with an organization, movement, or guru. That, at a minimum, implies organized application and distribution of set concepts and beliefs, probably on a commercial basis. Useful movement-specific data includes stereotypical strategies of the movement, any known movement gurus, the typical responses to court and state action by persons affiliated with the movement. Moreover, members of the community have proven violent, always important fact. So yeah, sometimes they're loners, sometimes they're unaffiliated, sometimes they go in groups, sometimes they go to each other's groups, sometimes okay. So that's a little bit about them in several different varieties. Okay, now that we've learned a little bit about the varieties, what are their tactics in court? I'm so glad you asked. This court experiences, personal and by other members, and the relevant case law has indicated that persons who engage in this litigation tend to adopt certain stereotype motifs in their written materials and in court conduct. The vast majority of these indicia are almost never shared by other self-represented litigants, including by those who have difficulty communicating their positions and arguments, and by litigants who are affected by cognitive and psychological dysfunction. So, yeah, these people all share similar strategies and similar behavior. But people who are not these people, these arguments are not seen in other people, including people who might be crazy. So they're in a whole special world unto themselves. The crazy don't say this. The people who have difficulty communicating don't say this. The soft sits say this. They're in a league of their own. Language that has biblical or religious aspects to it, though common, is not a definitive indication of this context. Much of that is also present in a broader self-litigation community. So yeah, the soft sits cite the Bible, but so do other people. So that alone doesn't do it. What follows is an incomplete summary of elements that we suggest that when a person has been exposed to these concepts, is part of the community or has adopted their litigation strategies. Great. Tell us what to look out for. These features were identified from a reported case law, from experiences of the justices of the court, and documentation received by this court. To be explicit, however, these indicia do not prove any claim or action invalid, or that the litigant is vexatious. They are telltale fingerprints that are found in litigation, and that if identified might warrant closer review. So these are some warning signals that might pique your interest. All right, so what are these warning symbols? Well, they go to documentary material. Documentation filed by these litigants also often includes many unusual features. Their significance is, if any, opaque. Courts, lawyers, and litigants may find it helpful to identify persons with expertise in the rationale for these motifs, so further review of the indicia approach the telltale fingerprints on a scientific rather than anecdotal basis. Beyond that, the documents are highly variable. They range from what appear to be professionally prepared, polished materials to crude assemblages of photographed pages with inconsistent fonts, formats, and paragraph and page number that imply copy and paste composition. Sovereign citizen documentation is sometimes flamboyant, with multicolored text, bright watermarks, graphics, and elaborate ornamentation on colored paper. However, this is not necessarily that useful to identify. Sometimes the documentation may be so disjointed that the fingerprint motifs are the only evidence the author is not suffering from mental or cognitive disturbance. That's pretty funny. Their papers are so incredible and crazy that the only sign of their sanity is that they're able to read and regurgitate these motifs. That's pretty bad. This is particularly true for documents prepared in accordance to legal grammar of Miller, whoever that guy is. All right, let's learn some things. The names motif. Oh yes, we've heard a lot about names. I don't go by that name. I don't recognize who a Darrell Brooks is. Okay, let's learn about the name motifs. The vast majority of these litigants use highly stereotypic formats to name and identify themselves. The most common form adds atypical punctuation, usually colons and dashes, into a name. Any litigant who uses a dash colon motif almost certainly has some kind of background in soft sit land. The most common version of the name format is colon, first name, dash, middle name, colon, last name, colon, or first name, dash, middle name, colon, last name. The difference is, in the first alternative, is it has an additional colon before and after the name. Yeah. For example, soft sit guru David Kevin Lindsay stylizes his name as David Kevin Lindsay. There are many variations on this basic form with various combinations of colons and dashes. Mr. Mead in his documents identified himself as Dennis Leary Meads all lowercase Dennis Larry Meads or all lowercase Dennis Larry of the Meads family The dash colon motif has no legal significance or effect. The rationale for this dash colon motif is unknown. However, it seems to be derived in some manner from the legal grammar of Miller, whoever that jackass is. A second common name motif is that a litigant identifies him or herself as being first name, middle name of the clan last name, or first name, middle name of the house of last name. I didn't know I could just declare myself to be the house of thinking. Can I just be Kurt Mueller of the House of Uncivil Law? Kick ass. I now need to design a shield. And like, you know, shit. So I can go to war. Mr. Meads also somehow employs the clan family house name motif, but he combines it with the dash colon motif to create the hybrid colon dash Dennis dash Leary colon of the Meads dash family colon. Heraldic device? Yeah, okay. Yeah. The fan family house motif is also meaningless. Hey, no, it has meaning to us. You all can be of the you guys can be of the House of Uncivil Law for a mere 99 cents a month. You too can become a part of the House of Uncivil Law. It's true. Merely by hitting that join button, or by hitting the link in the video description, or by hitting the link that's in the chat, you too will become a member of the House of Uncivil Law and get to use the name Uncivilian. Please click the join button today. Let's go back to our story. For $99.99 a month, you can even use it on legal documents. Ugh. A third name phenomena in litigant states their name in duplicative form, one with only uppercase letters, the second with either upper or lowercase letters, or only lowercase letters. Again, Mr. Meads' written material shows the motif. For example, the signature of 2012 notice for order to show cause has all uppercase Dennis Larry Meads by Dennis Larry below a handwritten signature. The duplication extends to handwritten signatures. For example, most of Mr. Meads' documents are double signed, with one signature reading all uppercase Dennis Larry Meads, then normal case Grantor, and the other Dennis Leary Meads grantee. The capital version of the signature is printed in black and in black ink, while the dash colon version is in red ink and handwritten. Meads extends this double names form to others, including his wife, lawyer's assistants, but strangely not the court. Okay. It appears that duplicate names of this kind are usually an indication that OPCA litigant has adopted a double split person strategy, which the letter is going to be reviewed in detail. In brief, the capital letter version of the name is some kind of non-human thing. That would be like the corporate form that we've heard a lot from, like Daryl Bronx, right? While the lowercase name is the flesh and blood aspect of the litigant. The red color ink is presumably intended to represent blood. OPCA materials are rife with this kind of arbitrary symbolism. Another name indication of OPC litigant is the litigant marks their name with the copyright and or trademark indication, usually the registered copyright, T inside parentheses, and TM symbols. Their markings likely indicate a fostering of a unilateral argument strategy. Okay. That was a lot about their names, but it doesn't stop there. Let's learn more about their document formalities and markings. The litigants frequently mark their documents in unconventional ways. The meanings of many of these marks is unclear and certainly have no legal significance. It may be that these motifs simply are theater, used by gurus to impress their customers and create what appears to be powerful documents. Indicia that appear restricted to OPCA documents include a thumbprint, typically in red ink, though in certain instances our court has encountered litigants who injure themselves when presenting documents to the clerk courts so they can make a thumb mark in blood. More than one signature, also in an atypical color, such as red or green ink. Attaching one or more postage stamps. Sometimes the stamps have text or signature ran across the stamp. And in certain instances, these stamps are simulated and simply printed on the document themselves. But OPCA litigants sometimes appear to imbue notaries with extraordinary court-like authority. That may explain why so many OPCA documents, including those filed by Mr. Meads, are often notarized when that formality is neither legally necessary nor appropriate. I will later comment on the responsibilities of legally trained persons not to notarize documents in that manner. I mean, to the best of my knowledge, a notary is just verifying a signature. So I don't know Canadian law, but to the best of my understanding in American law, like a notary is just validating the signature. So like a notary can notarize anything. I don't know why you want to necessarily, but okay, maybe not in Canada. Okay. Anyways, carrying on. A notary cannot give special status to a document. Well, that much is true. I mean, all they're doing is validating the signature at best. They can't do anything more than that. One very peculiar form of notarization is an indication of a specific money for nothing scheme. This is a document that will have text written or stamped across it, typically at a 45-degree angle off vertical. The text will include the phrase "except for value" or "accepted for value." Yeah. Typical Targetman's document marked this way include birth certificate, a bill to the litigant, a court order against the litigant, a demand letter, or court documents filed by an opposing party, for example. One example stamp that was apparently stamped on these documents includes the following. So someone went to Office Depot or something and got a stamp made, I guess, which said the following. Non-negotiable, accepted for value, approved for payment, accepts for value the presentment and all related endorsements, front and back, in accordance with the Uniform Commercial Code. They're writing this in Canada? Yeah. This is a Canadian case. What the hell are you doing? This is Ontario. What the hell are you talking about, the Uniform Commercial Code? That's an American thing. What the hell? Okay. In House Joint Resolution 192. Okay. Please release all proceeds, products, and accounts and fixtures and order the court to me immediately. Exempt from levy. Deposit to the United States Treasury. You're not in the United States, sir. And charge the same to whatever. Stamp versions of the motif will often have spaces for handwritten components. The particular notation has many variants, but all except the accepted value language, and usually mention the UCC, which doesn't exist in Canada. Also, for what it's worth, like, I know this is a point that will, like, just states the obvious. But everyone who's like using the UCC as a basis of like fundamental rights, the UCC was invented. I think it was like 1977 or something. I'd have to double check. The UCC is a comparatively recent invention in American law. It's, you know, there was a time when there was no UCC. Because someone invented it. And then it was good. And like everyone adopted it because it was really, really good. But it's okay. I mean, yeah. Okay. Anyways, carrying on. The documents okay, so now we're going to learn more about specific phrases and language. Oh joy. Let's learn more about specific phrases and language. The documents frequently include atypical language and terminology that indicate the sovereign citizen affiliation. Presumably, some of these terms have symbolic or scheme-related significance. These are helpful indicia to help identify them. Documents frequently refer to litigant as having a particular status or characteristics, such as a flesh and blood man, a freeman on the land or freeman, a free will, full liability person, as opposed to a free will part liability person? Why wouldn't you want to be like a part? liability or limited liability person. Wouldn't limited liability be better? Okay. A sovereign man, sovereign citizen, or sovereign. Okay. SOVRAN, sovereign. Sovereign. That the litigant is a person or natural person, but not a corporation, is not a person. We heard that from Darrell Brooks. Was created by God, is only subject to a category of law, typically natural law, common law, or God's law, is an ambassador, is the postmaster general. I didn't know that one either. I didn't know that sovereign citizens just claim to just be the postmaster general. I didn't know that's a thing you could do. Just say, I'm the postmaster general. Okay. Is a member of a fictitious nation state or aboriginal group, represents or is an agent or secured party for similarly named individual or thing, like third party representative, yeah. And is a private, neutral, non-belligerent. Okay. Most of these items are strong indicia with the exception of those who invoke God or religion, which also stereotypically emerges in submission to certain persons with mental health impairments. Identification that a municipality, province, or Canada is a corporation is a clear indicia of sovereign citizen thinking. A litigant with documents of this kind will typically be using the everything is a contract scheme discussed below. Similarly, a statement that the court is an admiralty or military court suggests sovereign citizen affiliation, particularly when in an inappropriate context, such as litigation that does not involve military personnel, ships, or maritime subjects. Any use of the phrases accepted for value, except for value, and return for value. And that phrase is going to haunt my dreams for a little while now. I'm not going to lie. Except for value and return for value is definitely going to haunt my dreams for a little bit now. But Darrell Brooks was not the first person to think of it. Any use of the phrases such as except for value and return for value, or except for value and consideration and honor, indicates sovereign citizen affiliation, but not necessarily the use of A4V scheme. This language arises in multiple contexts when incorporated in a document. A statement that the court, government, or official is de facto is very indicative of sovereign citizen affiliation. Many documents, including those of Mr. Meads, feature a declaration concerning service, such as service to an agent is service to principal, and service to principal is service to agent, presumably an attempt to expand the notification function of these materials. The term straw man usually indicates the double split person strategy. So does framing other persons or parties with duplicate names, one in uppercase letters, the other lowercase. A demand that remedy be paid only in precious metals, usually gold or silver, is typical of these litigants. Many of their backstories revolve around the idea that national currencies have no actual or little true value, hence emphasis on precious materials. Well, I mean, okay, I guess. All right, let me read some of your super chats because I've been reading for a little while now and I want to go back so it doesn't get too many of them, but let me read some of your super chats that have come in thus far. And thank you very much, everyone who contributes to the channel. As always, it is very, very appreciated. Lets me find the proper page. What day is it today? It is the 28th of October today. Great. Let's see. Chuck in Tennessee said, much love and respect, Kurt. Thank you very much. Tuscan Sky said, Kurt, congratulations on passing a second bar. You kick ass. Danielle Vargas said, is the topic touched at all in law school? No, because we learn law in law school, and this is bullshit. Harry Dickshaft said, hey, Kurt, I'm here as a third-party intervener of the account known as Harry Dickshaft. I accept for value and return for value. Yay. A. Caperiton says, I think this week can be summarized as what? Della Sandor says, clarity and comedy. Kurt for Supreme Court. Jim Tussing said, this is just because you said Runkle. Where's my magic hat? Love what you do. Rock on. Della Sandor says, just because I appreciate you, // period. Good. Scorch1028 said, what do you think of sovereign citizen squatters who claim they cannot be removed from a homeowner's property? I can think of ways to remove them from their property. Primer says, sir, this is Wendy's. Purilinota says, I am uncivil. I'm Saucet, I demand uncivil's hat. And Ron White says, Kurt, thank you for this explanation. You're welcome. I thought we would take some time to go through the full panoply of the bullshit so that we all understood the bullshit better. Yeah. Much more of this, though, and I'm going to need to break out my new whiskey glasses. Because, you know, yeah. Let's see. Legislation and legal documents. Many of the sovereign citizens' documents mention certain obsolete, foreign, or typically otherwise irrelevant legislation, including the Magna Carta, yes, the Uniform Commercial Code of the United States, often similarly referred to as the UCC. This is sometimes mistakenly named the Universal Commercial Code. Yeah. The Constitution of the United States, not so relevant in Canada. Other American and federal legislation, again, not so much in Canada. UNIDROT and UN CRITRAW, Contract Interpretation Dispute Guidelines. Versions of the Income Tax Act other than the current legislation. The 1948 Act of the legislation is a particular target. Oath legislation, such as Alberta Oath of Office Act and the Federal Oath of Allegiance Act. Any version of the UK Coronation Oath. The Canadian Bill of Rights. The Statute of Frauds, that's a contract principle. One contracts have to be evidenced by a writing. That's the Statute of Frauds. The 1931 Statute of Westminster. And then April 10th, 1933, Order in Council that abandoned the gold standard for Canadian currency. Okay. Reliance on Black Law Dictionary, particularly an obsolete version of Black Law, is suggestive. I need to get a copy of Black's Law Dictionary. I should just get a copy just to have around. Yeah. OPCA litigants also stress the relevance and quote from the Bible, usually King James Version. A person's birth certificate is a focus of these sovereign citizen schemes. Any mention or reproduction of that certificate in atypical circumstances is strong indication of sovereign citizen. Atypical mailing address. Oh, good. Well, the Postmaster General's, no, sorry, that's the other way around. Apologies. The Postmasters General, that's the right way. The Postmasters General over here apparently also like to adopt unusual mailing schemes. So let's learn about the mailing schemes of the Postmasters General. The OPCA litigants sometimes use abnormal formats and elements in their mailing address. A common feature is the omission of a postal code or some variation of a postal code's usual format. For example, Meads frequently encircles his postal code with square brackets. Other times he states the postal code as near the postal code. Other litigants replace their postal codes with land registration information, such as the Torrens registration location for their mailing address. Yet another motif is the return address includes care of a third-party acceptor or no code non-commercial. Any avoidance or variation of postal code strategy strongly suggests sovereign litigants has adopted an everything as a contract scheme. OPCA litigants in the contract category apparently believe the use of the postal code means accepting some kind of contract with the state. But not the Torrens registry location. Okay. Another variation is that their address is in some manner stated to qualify the manner of delivery. For example, Mr. Meads has filed several documents that include the phrase non-domestic to Canada after the postal code. This implies the litigant is not in Canada and therefore presumably not subject to Canadian authority. Okay. Sometimes a litigant will demand he or she only receive mail in an unconventional manner. For example, Bellinger, in correspondence with my office, has instructed I only send him mail in the following manner. Okay. Edward-J-Robin, House of Ballinger, non-domestic mail, care of the Church of Ecumenical Redemption International, Street Address, Edmonton, Alberta, postcode exempt, no code, non-commercial. Failure to comply with means I am guilty of fraud, conversion, and coercion, and further become consenting and contractually bound debtors to the church. These sovereign citizens sometimes include fictitious nation states in their addresses, or indicate their mailing address as an embassy. That'd be cool. Maybe I'll do that. Maybe I'll just start making part of my address the Embassy of Uncivil Law. It's, doesn't have any legal significance, but it kind of sounds cool. We could have an official embassy flag and, everything. It has absolutely no power, but, hey, the Embassy of Uncivil Law sounds pretty good. Maybe we'll do that. Is there an embassy registry I can file some paperwork with or something? I don't know. OPCA litigants also have a pattern of addressing governmental and non-officials in characteristic double name format. Name in upper and lowercase letters doing business as, name in uppercase letters only, title of the official. For example, this court has received correspondence addressed to, in part, Stephen Harper, doing business as, all caps, Stephen Harper, Prime Minister of Canada, CEO Canada, Inc. This is again in 2012. This is before Justin Trudeau's time, so Stephen Harper. This motif usually indicates the litigant has adopted everything as a contract scheme. The examples identified above will very likely, okay, now we're going to learn about the conclusions of this. The examples identified above will very likely be encountered in related but variant forms. I have been looking for names for the different membership levels, because right now they're just like level 2, 3, 4, because I didn't know what to call them. Because they're just called also, we have different membership levels now. They're uncivilian, and then level 2, level 3, level 4, because I didn't know what to call them. But, maybe the embassy thing is good. Maybe if you're a level 4, you get to be a ward of the Embassy of Uncivil or something. There's potential. And you get special emojis. Yeah, we'll have to create a special emoji for the tier 4 level or something. That is the flag of Uncivil Law, so that you get the cool flag and you can flex on the other uncivilians. Ideas. Is Ian unwell? I didn't know that, Secret McSquirrel. I hope he gets better. I can sell him I can sell embassy ships. Yeah. This is not a bad idea. I will send you a certificate in the mail. I will send you a certificate in the mail with a wax stamp and everything. I'll make it nice. I'll get some nice paper, and I'll get a nice little wax seal or something. Maybe I'll pay someone to do some calligraphy. That could be good. And we'll get a wax seal on there, and it proclaims to everyone that you are a member of the Embassy of Uncivil Law. There's ideas here somewhere. The examples identified above will very likely be encountered in related but variant forms. For example, Mr. Meads expresses the flesh and blood man variant as the living flesh and blood sentient man, and that he is the creation for the Lord God Almighty Jehovah. Similarly, Mr. Meads expressed his copyright interest in his name in different manner, all caps, Dennis Leary Meads, copyright for the province Alberta. I note parenthetically that this notation is nonsense, given the Constitution Act explicitly assigns jurisdiction for copyright to Canada. These stylistic variations do not necessarily imply the documentation is not of sovereign citizen origin. There is a certain crude level of creativity and adaptation practiced by these litigants and gurus that's led to many meaningless variations in their irrelevant motifs. Yeah. The speed dating hasn't been particularly effective as of yet, I'm sorry to say. But thank you for asking. All right, in-court conduct. The litigants often engage in unusual in-court conduct that seems to be in part because many of the litigants are following a script prepared by their gurus. This was apparently true for Mr. Meads. For example, in certain points of the court hearing, he appeared to be reading word for word from prepared documents. Other aspects of the speech seem rehearsed. Demands. Common scripted motifs include demands by the litigant to see the oath of office of the judge, lawyer, or court official, that a judge prove his or her appointment. The judge makes certain oath or statements, such as the judge is a public servant, to see bond information of a litigant, judge, lawyer, or court official, that the court indicate the basis or scope of its authority, that the Crown provide proof it has authority to proceed against the litigant, that the opposing party provide proof it has authority to proceed against the litigant, for a certified copy of a document or legislation, that the court state whether it's addressing the litigant in one of two roles, such as whether this is to the legal person or corporation versus flesh and blood person or natural person, and so forth and so on. Yeah. I will now read a few additional of your super chats because let's take a break. Della Sandor said, love your take on this. You're a comedian too. Huge. Thank you. I've been working on my comedy. Like I do improv classes and I need to get back into it because I haven't been doing improv classes a lot recently, but I definitely need to get back into it because the improv helps because of course running a YouTube channel, especially a live, is all impromptu, right? Nothing's planned. So the more I do impromptu comedy, the better I'm at it. So, but I do appreciate it. Thank you. Delor Sandor says, you're a true friend to all of us. Community does kick ass. Gurjan says, what model of ecclesiastical pursuit chariot do you own? Stereophonics Mom says, how long do you study soft sit in law school? We don't because it's dumb. And Artie's Corporate Fiction, who is a lawyer on the YouTubes, who specializes in the soft sit, says Justice Rourke is the P. Barnes of judges, absolute legend. Artie Corporate Fiction, if you are still around in the chat and would like to join me for a while, we're not going anywhere, I think, in a while. We still have got we're on page 43 of 140. I think we're going to be here for a little while. So if Artie's Corporate Fiction is still in the chat and would like to join the stream, I'll figure something out. You want to join the stream, Artie? Let's see if Artie Corporate Fiction is going to join us. He can help us get through the pain. And he can also read some stuff and talk to the chat while I make myself a drink. All right, great. Artie's Corporate Fiction is going to be joining us. So since I'm doing this in OBS and not StreamYard, we have to do this the hard way. But that's okay. I am prepared for this because I've done this before. Dun, dun, dun. Do 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 dream magic of the moment of glory none in me you and me dream magic of the moment, glory night, memory lead us of me, you and me, Do do do. Do 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 do. Do do do. Do 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 do. I'm just a little silhouette of a man, Scaramouche, will you do the fandango? Someone didn't like me, very, very frightening me. Galileo, Figaro, Avicaro. I'm just a poor boy, nobody loves me. He's just a poor boy from a poor family, spreading his life in this monstrosity. Easy come, easy go, will you let me go? This Milosh, no, we will not let him go, let him go. This Milosh, we will not let him go, let him go. We will not let him go, let him go, let him not let him go, let him go. Oh, mamma mia, let it go. He lays a pop and it comes down aloft for me, for me, for me. So you gonna need my eye. So you're gonna never leave it behind. Oh, baby, can't speak enough to you, baby. These are rights you got it right now on me. Where's your Twitter, Artie? Do you have how did? Oh, there he is. I'm gonna send him a message. Great. Fantastic. All right, back without the voice mod app. So Artie will be joining us in just a moment. Great. Awesome. Now, while we're waiting for him, I can say that I've done all 12 of the triads as a light. So I've got lighting options for days. Joining the stream is Artie's Corporate Fiction. Hello, sir.
Hello.
Wow, that's a lot of voice.
What's going on, man?
Not much. I'm doing great. Why don't you tell the chat about yourself?
I am Artie of Artie's Corporate Fiction. I run a YouTube channel. I have been for the last couple of years. My primary focus has always been on sovereign citizens and similar litigants, and as well as First Amendment auditors, kind of dealing with the craziness that goes along with this this group of people. So that's been the biggest focus. I'm a licensed attorney in New York and New Jersey, yeah, that's basically it. When I'm not doing law tuber stuff like this, I'm playing Skyrim or Fallout. So
excellent. I've been playing Witcher 3 a lot lately.
I saw, which is awesome. It's a great game.
Yeah. All right, let me check your volume levels. Let me go into OBS. Say something.
Testing 1, 2, 3, 4, 5.
Yeah, I think you're fine. I just need to turn down myself a little bit so we'll match. Great, fine. All right, great. So we're here with Meads versus Meads, which is a classic and sort of sovereign citizen explainer bullshit, as I'm sure you well know. And we're just going through the court describing all the sovereign citizen bullshit and watching me lose my mind.
Mm-hmm.
Great.
Yeah. I've known about Meads versus Meads for a very long time. It is like the treatise, you could say, of sovereign citizens in a judicial opinion.
Yep.
U.S. doesn't quite have something as extensive as Justice Rook does.
Yeah. No, I agree. I think it's the most extensive work that's been done in a judicial opinion. There's certainly law review articles and stuff that cover it, but in a judicial opinion, I think it's the most thorough.
Right.
So we're learning a little bit about their styles and their tactics in court and stuff like that. So let's pick up where we left off. The litigants also present documents to the court or another party at the hearing itself without prior service of warning. Common examples include an attempt to present the judge or court official with documents that make the court a fiduciary, agent, or forced a contract upon the judge or court official, or present the judge, the clerk court, or opposing litigant with a fee schedule. That's cute. I didn't know that was an option.
Mm-hmm.
Another common motif is that the litigant I also didn't know that apparently the sovereign citizens call themselves Postmaster General. Did you know that?
Yeah. Well, that is a particular sect of sovereign citizens. I think Justice Rooks will refer to him if you haven't gotten that far. His name is David Wynn Miller.
Yeah, we read about him.
Yeah,
he's a fun guy.
Oh, absolutely. That particular group, they refer to the whole Postmaster General thing.
Yeah. Okay, great. Another common motif is the litigant will engage in various peculiar comments that relate to names and identification. For example, the litigant may refuse to identify themselves by name and stating that they're an agent or representative of the entity identified by name. That sounds suspiciously familiar as of late. Typically, these entities are described in the following manner: a person of the litigant's name, a corporation or dead corporation with the litigant's name, a legal fiction or fictitious corporation with the litigant's name, a trust named after a litigant, an estate named after a litigant, a dead man, or a straw man.
Yeah. Well, now you know the origin of my YouTube channel.
Yeah, so. yeah. I know. Yeah, because it's corporate fiction. Yeah, exactly.
Yep.
So your entire existence is a corporate fiction. It's a great channel name if that's your focus. I mean, it can't get much better. Also, your neon is badass. And
Thank you.
I don't know if it's necessarily my style, but it does look pretty kick-ass.
Thanks.
Additionally, the litigant may identify himself with a purely fictitious name via an alternative name format. We've learned a lot about the formats with the colons and dashes, more than I ever wanted to know. Also, I'm seriously considering setting up the Embassy of Uncivil Law and handing out like memberships and certificates and shit as a reward tier, because that sounds awesome.
That'd be awesome, yeah.
Similarly, the litigant may make an unusual mention of copyright or trademark, typically because the litigant claims copyright or trademark in their own name. The litigants frequently deny a court has jurisdiction over them. Direct denial the court has authority over the litigation. Identification of some physical elements of the courtroom or courtroom dress that indicate the court is a military admiralty court. That flag, or that eagle on top of the flag, which to be honest, I hadn't really heard about the eagle on top of the flag. Much more common, the gold fringe on the flag, not the eagle on top of the flagpole. But whatever. So he can't even sovereign citizen, right? But okay. A statement or declaration that the litigant is only subject to a specific category of law, most often expressed as natural law or the common law. Well, if you really think you're subject to natural law, we could just let you out of the courthouse and let nature take its course, because that should end pretty well at this point. The court is restricted to certain domains of law, usually legislation, military law, and or admiralty law. The court is only a de facto court, or the judge is only de facto. Well, very de facto, extremely de facto, all the de facto. Also de jure, but still. A declaration that the litigant only takes certain steps without prejudice or without consent or restriction to the litigant's right, or declaration the litigant's presence or participation is under duress. Other stereotypical soft behavior includes a refusal to pass the bar. By the way, here they mean the physical device in the courtroom when they say that.
Yeah.
This is what the physical barrier. This is what the bar exam is named after. This is what the bar as a concept is named after. They refer literally to the gate that you see in courtrooms. You see the part that separates the business end of the court from the spectator end of the court, and they mean literally here passing from one end to the other end. That's what they mean. Reliance on Black's Law Dictionary, and usually an out-of-date version. I remember 3rd edition being particularly popular, if memory serves.
I've seen mostly the 2nd edition, but I've also seen generally between second through 4th editions.
What are they on now? Do you remember?
right now. One of my viewers actually, as a gift, she bought me the latest version of the 12th edition.
Excellent.
The full-on hardcover too. So
yeah, no, I think I need to get a hard copy of the latest edition. I think that'd be good to have sitting around. If I can find a hard copy of a second edition sitting around, I'll get one of those too. That'd be good. Maybe I could just have all the editions. Show us, Artie. Show us your wares.
Oh, it's the 11th edition. I thought it was the 12th, but no, the 11th edition is the current one.
Okay.
Yeah.
Very exciting. Inquiry is whether the court is attempting to create a contract with litigant. Refusal to enter or premature departure from the courtroom. This is often accompanied by denial of court authority. Ritualistic responses to inquiry, such as repetition of what seems to be formal automatic responses, such as, I accept that for value and honor.
Mm-hmm.
Yeah. Your Honor, I accept for value and return it for value for settlement closure in this matter. You're intimidating, or are you intimidating me? Yeah. These various motifs are usually found in combination. A useful and representative sample transcript of this litigation is found in whatever case. A particularly difficult category of the litigant are those who adhere to the concepts that all interactions between state, court, and individual are contract. As explained in greater detail, persons who accept this concept will interpret almost any invitation by the court or compliance with the court procedures as formation of contract. For example, members of this court have observed litigants who apply this principle of everything as a contract strategy will simply refuse court directions and processes, such as to enter the business side of the courtroom, sit, stand, or acknowledge their identity. Similarly, litigants who refuse to identify themselves but claim to be representatives of the entity related to the litigant.
Mm-hmm.
And then Darrell Brooks was particularly interesting because he claimed to be a representative of the entity and also claimed he never met Darrell Brooks, which is a weird trick.
Yeah, so I don't even know why he kept on, because he also said he was a third-party intervener, but he also said he was representing his client, which is not him.
And that he's never met his client.
True.
Yeah. Do you know where your client is?
I honestly wish the judge would just simply ask him, what's the name of your client? You know, I would wonder what he would answer, what his answer would be for that.
Yeah. A particularly difficult category of litigant are those who adhere to okay, we read that one. Similarly, litigants who refuse to identify themselves but claim to be a representative will also maintain this role in face of strong court ruling. These litigants are also very argumentative. The manner in which refusal occurs is often highly formalistic. For example, Mr. Meads made this bizarre response to suggestion of cooperation. You're treating the person, Dennis Meads, with all these statements and not the living soul. You're enticing me into slavery. Darrell Brooks didn't try the slavery line. That would have been good. The March 3rd, 2011 document uses the same language as indicates the same motifs. These are the signs of everything is a contract. The litigants, materials, and court strategies usually exhibit many of these features. Thus, they provide a certain redundancy that makes these markers a helpful indication of particular litigant has purposely adopted vexatious pseudo-legal strategies intended to frustrate the operation of the court. As noted, these specific indicia almost never encountered with non-litigants, including those with either cognitive or psychological dysfunction. So you have to be, not even being stupid, not even being mentally handicapped would lead you to these arguments. So that's how bad they are. The litigants often prefer to make their submission in a highly complex and indirect manner. As a consequence, the court experience has been that a typical submission will incorporate a great many of the indicia that are identified here. This too creates a high confidence that documents have this affiliation. So then the court suggests some responses. By the way, if you want to talk or read something or whatever, just let me know.
Sure.
Given the intrinsically vexatious nature of the methodologies, which I review in detail below, it's appropriate the court adopt special procedures for documents, which may include the clerk rejects materials that do not conform with required standards. The clerk accepts and marks those individuals as received rather than filed. The materials that disclose characteristics may be reviewed by a judge without further submission or representation. The judge may declare the litigation, application, or defense frivolous, irrelevant, or improper. Order the documents are irrelevant to the substance of litigation. are only retained on file as evidence of that's potentially relevant to costs against litigant, vexatious status, or whether the litigant has engaged in criminal and or contemptuous misconduct. Reject the documents in order that if litigant wishes to continue application or defense, the litigant then file replacement documentation that conforms to formalities, or the litigant to appear before the court in a show cause hearing to prove the litigant has an actual defense in law. Here we're thinking civil law, by the way, not criminal, for a show cause hearing. Although I suppose you could have a show cause hearing in criminal law too, but that's more around the contempt area. Assign fines is authorized by rule. This is one of the reasons like the court here had such problems with Darrell Brooks, because like contempt wasn't really an option. You can't fine him because he doesn't have any money. You can't send him to jail because, you know, he's already there and staying there forever. So like holding him in contempt does nothing. So it's pointless. Although it would be hilarious if the judge in sentencing him sentences him to the first 76 counts and then says, oh, by the way, I'm also just creating count 77 for your contempt, finding you guilty and sentencing you to additional 6 months. That'd be great.
Just one final fuck you before he's gone.
As well, F you at the end. Yeah. You can't do that, Your Honor. I certainly can't. Direct criminal contempt, go to hell. Anyways, OPCA litigants are known to engage in disruptive and inappropriate in-court conduct, especially if he acts like a fool during the sentencing hearing, because that would give you like all the bases you know, and you know he's going to. So you just have that. You just have that page ready to go. Just slip it in there. It's like, charge 77, contempt of court. I find you guilty. 6 months. Anyways, okay. Litigants are also known to engage in disruptive and inappropriate conduct. For example, in some case law, and sometimes appear with supporters who do the same. The misconduct extends to disrespect, threats, in some cases violence directed to court personnel. Yeah, there was a reason that we had this shock thing on his ankle. Hey, Artie, now that the judge is back, do I still need this shock collar on my leg? Can we have that removed?
Yeah, sure. I couldn't believe it.
Litigants have an alarming predisposition to believe they can take justice in their own hands and act against the judiciary. The attempted arrest of a judge is an example. Yeah, that's always fun. When they attempt to arrest judges, pretend they are judges, stuff like that. That's fun times had by all.
Or try to arrest entire police departments.
Yeah, that's always good. That usually doesn't end very well. Where would you take them if you? Where would you hold them?
Certainly didn't. Exactly. Well, I don't. Have you actually heard of this? This happened maybe a month ago. The self-appointed Queen of Canada, Didulo, that's her last name. Her followers tried to a group of 30 of them tried to actually arrest a local town's police department. The police department locked the door so they couldn't go in, but they operate on the presumption that we're going to citizens arrest you and then we're just going to hold you until the military arrives to take you into custody. Well, long story short, that didn't happen, and then 2 of them were ended up arrested by the police themselves and taken into the department.
Yeah. The military's going to show up. Who's calling them?
Apparently, the Queen of Canada. Apparently.
I mean,
look, I'm just saying what happened. I'm not saying whether it's actually rational or logical.
I was just curious what the game plan was. I was, just ask questions.
Yeah, if your chat hasn't heard of her, Romana Didulo is the self-appointed Queen of Canada. Yeah, it's a definite rabbit hole.
I have not heard of her. She sounds fun. Maybe we could get her on an interview on Uncivil Law and she can explain her proclamations to the world. Okay. These litigants have an alarming predisposition to believe they can take justice in their own hands. More recently, during the trial of an associate, the defendant referred to a YouTube video showing people swarming the courts of England to demand justice and chasing judges from the bench. There's a reference to the public who are paying close attention to this and relating proceedings with growing numbers. While Justice Meyer chose to give Mr. Larson the benefit of the doubt and assume this was not meant as a veiled threat, I think this very effectively illustrates the potential activities that judges and court officials can expect. They have been incited by the misguided and dangerous rhetoric spewed by their gurus, and this ranges the troubling possibility of in-court misconduct, if not physical risks. Um, oh, Ron White, my address is listed on my about page of my channel. So if you just go to my channel and you go to the about page, it lists my physical address for mailing and packages. So thank you, by the way. I appreciate that. That's why I got these. Did you see? I got these really nice whiskey glasses from a person recently.
Nice.
That was kick-ass. And I got these nice shot glasses and stuff too. So hey,
awesome.
my collection is improving every day. While Justice Meyer chose to, okay, we read that. The litigants often attempt to rally the troops so that groups of supporters appear to be at a hearing. This can lead to orchestrated disruptions, including threats directed at judges. Our court has experienced high-tension incidents, particularly of freemen on the land and other members, where persons in the public gallery have had to be expelled, sometimes with force. It is therefore appropriate the court may adopt specific in-court and security procedures in response to these people. Additional in-court security is generally warranted. In particular, the court has discovered the litigants will make clandestine audio and video recordings of court proceedings in violation of court rules. These are often then posted on the internet. Well, that wasn't much of a threat here since everything was being broadcast everywhere, but whatever. The fact that the litigants involves these motifs may also be a basis for a judge to order a courtroom closed to the public, particularly if a person in the public gallery disrupts proceedings or poses a physical threat. Well, that too, we can throw the public out of the courtroom too for being disruptive. I made an order of this kind about allowing public entry, subject to search and removal of prohibited electronic recording equipment. Though the concepts initially appear to be diverse, they may be grouped into a limited number of general categories. In this course experience, apparently novel concepts very often recycle old schemes, but use somewhat different terminology. They're still searching for the magic words. It's Wingardium Leviosa, not Leviosa. If they just say it just exactly right, man, it will work.
Oh, that's how the gurus like get out of scrutiny. They'll say, "Oh no, you didn't say Wingardium Leviosa at this exact particular moment in the hearing, and therefore they had jurisdiction over you." And that's exactly how a lot of these gurus say, if you don't, write in red ink at a 45-degree angle, accepted for value, then it doesn't work. You have, it's always something that they could do that you didn't do the incantation right. That's all. Would
you like to work with me in constructing your own sovereign citizen manual and selling it? We can make some money, Artie.
Let's do it.
Great.
For sure.
Step one, don't. Okay. Throughout
Step one, no.
Though these concepts initially appear diverse, not so much. Different concepts and arguments are often interwoven. Concepts from different general categories often appear in the same document argument, as the litigants freely interchange and mix the ideas. As Mr. Meads' materials and arguments illustrate, even a single letter may apply numerous concepts from multiple schemes and concept categories. This mixing and layering occurs even when the result is illogical. Logic and the sovereign citizen have no intertwinement.
The only way you can logic, a sovereign citizen train of thought, and this is something I've realized after studying these guys, is that you have to accept certain false premises for it all to make sense down the line. So, for example, in order to understand why they cite the UCC, for example, in a freaking traffic case, the only way you can suss that out is to accept the premise, their initial premise, that every interaction with a government entity is a contract. So if that's true, then of course the UCC would apply, because the UCC applies in a lot of commercial transactions, and therefore that's why they think it's appropriate to cite the UCC in a criminal case. But you have to accept those false premises in order for later things to make sense down the chain.
Yeah. The one that always sort of, as I was saying earlier, the thing with the UCC is like, it was just invented at one point. Like your rights, if your rights come from the UCC, it's pretty dark about most of history, since the UCC was only invented in like 1977 or something. So, okay.
Yeah.
Okay, as the arguments illustrate, even a single letter may apply numerous concepts. For example, Mr. Meads claims to only adhere and be subject to God's law, yet emphasizes the alleged operation binding universal character of the UCC. Those do seem like contrary ideas. Unless the UCC was created by God, which I thought it was created by the, what was it called? Trying to remember the name of the organization that actually created the UCC. Oh well, that was too much of a deep reach for my brain. As a preliminary note, review of the case law and the court's experience indicates the concepts and argument do not generally rely on the Canadian Charter. This may reflect the fact that most of these concepts are adapted from American precursors, or the typical litigant is unwilling to shield themselves under the authority of the Canadian Charter. They instead prefer to frame their arguments around the Canadian Bill of Rights, which has a well-established limited legal effect. Yeah, well, that's Canada for you. Their Bill of Rights doesn't really matter, but you know, that's Canada. That's one of the reasons I'm glad to be an American. The litigant is not subject to court authority. A very common scheme category is the litigant is in some manner outside the jurisdiction of court or state, or somehow rendered immune from legal obligations. This category has three general forms. The jurisdiction of the court is restricted to certain specific domains, and the litigant falls outside these categories. Sounds a lot like subject matter jurisdiction. The jurisdiction of the court is eliminated due to some defect, and the litigant is in some manner immunized from the court action. A common and older concept is that the Canadian court has restricted jurisdiction. The majority of these schemes appear to have American origins. Well, the Canadians apparently brought to us the freemen of the land. Apparently that was their fault. And Ian Runkle also is responsible for creating a cult in Alberta. So, you know, they're responsible for that. And so we'll carry on with the rest. A typical situation is that the litigant may claim a court is a military admiralty court and therefore has no jurisdiction. Once the true nature of the court is unmasked, the litigant will declare themselves immune. This, of course, has been uniformly unsuccessful. Mr. Meads at one point pursued this approach in his oral arguments. He demanded to know the meaning and significance of the Royal Coat of Arms of Canada attached to the back of the courtroom behind the bench. Well, I imagine the Royal Coat of Arms' significance is that it's the Royal Coats of Arms, and you know, the Queen is, or now King, is still head of state. So yeah. Once I translated the law and motto from sea to sea, Mr. Meads declared it meant that the Alberta Court of Queen's Bench was an admiralty court. That's cute. I like that one. The motto from sea to sea means we're an admiralty court. That's cute. Which has no jurisdiction over himself. Mr. Meads was in one sense correct. The court can potentially address admiralty law matters subject to legislation assigns jurisdiction to the federal courts. Admittedly, landlocked as Alberta is, legislation of that kind is not exactly a common occurrence. Mr. Meads, however, is manifestly mistaken. He thinks it's sole jurisdiction of the court. Well, being landlocked isn't necessarily a barrier to having a navy, because I'm trying to remember, but there's a couple states, because every state has National Guard, right? Mm-hmm. Which is like the Army equivalent. But some states have other military branches equivalents. They have like an Air Force equivalent, and they have a Navy equivalent. I'm trying to remember. It's like Idaho or Montana or something has a naval state force, despite the fact that, you know, there's no ocean.
Really?
Yeah. So being landlocked is not necessarily a barrier to having a navy, apparently.
Yeah, I can't call it.
Yeah. Anyways, another admiralty law-based argument illustrates how the word includes seems to baffle the litigants. Lol. I have personally received a foisted unilateral argument that explains that Canada is restricted to the oceans that surrounds the landmass and internal water. Later explains this basis of argument by some act, which reads in part, in every enactment, Canada, for greater certainty, includes the international waters of Canada and territorial seas of Canada. So that means only those things. The author continues to declare that Canadian courts are nothing but pirates. Ooh. Operating on the high seas of commerce, looking for some prize and thus de facto courts
Well, just like the cops are all road pirates, you know?
If you want to sail the sea, you are a pirate. Yo ho, then leave me. He's in life for me. I don't remember being offered to become a pirate as part of my bar membership, and I feel very, very cheated right now, I have to say. OPCA litigants who advance these schemes will often focus on certain aspects of court formalities. Like Mr. Meads, they may scrutinize the court for some hidden indication of the true nature. A strange but common belief is the flag with the yellow or gold fringe denotes military jurisdiction. Yeah, this is the gold fringe flag, which is why Brooks with his eagle on top of the flagpole thing was kind of off.
I can't remember. Did he actually mention the eagle on the top?
He did mention the eagle on the top, yes, and then talked
I
about.
I missed that.
And then he talked about the president and commander in chief. There was a brief moment where he got into it a little bit. The motion and argument that there was no lawful reason for Canadian flag to be present, other than the regulatory statutory authorized flag, was frivolous. I'll tell you what, though, if I ever become a judge, I'm just going to have a non-gold fringe flag. I'll go to the store and buy one myself. I just don't need the headache in my life. I'll just put up a non-fringe flag for whatever value it has. It's fine. I'll go to Walmart, get myself a flag, whatever. Another curious belief that purports to limit the court jurisdiction is that notaries, as a kind of law official, in some manner possesses judicial or judge-like authority that displaces the authority of Canadian courts. A sovereign citizen litigant made the following claim: where it is my understanding I can use a notary public to perform duties found under any act. Wow. Notaries can, okay. Thus they have the power to hold court and hear evidence and issue binding lawful judgments. Wow. Okay, I didn't know becoming a notary gave you these powers, man. Becoming a notary sounds kick-ass. Whereas it's my understanding that notary public can also be used to bring criminal charges to bear against traitors even if they hold the highest office. A notary public can. Notary publics are sounding really, really great right about now.
Right.
Man.
I mean, in my experience, I've never seen a sovereign citizen like make this kind of sweeping declaration about the power of notaries. I've only ever seen sovereign citizens try to rely on the fact that their, affidavit of whatever crap is notarized, and therefore it carries more legal weight than it really does. That's the only time I've seen them reference notaries, is to say, well, it's notarized, therefore, you have to accept it, or you have to accept its validity or something like that. And of course, like, no.
Yeah. Naturally, this claim is rubbish. And the litigants offer no foundation for the concept. The relevant legislation does not authorize notaries to function in this manner. No shit, Sherlock. While I am a notary, as a consequence of my office, as a judge, apparently he's also automatically a notary. And incidentally, I believe in some states, lawyers are automatically notaries, in some states as well. Not in any state I've ever lived in, but still. That does not make all notaries judges. Right. So he's a notary. It doesn't mean that everyone who's a notary is a judge. Right. Litigants often assign special and misplaced significance to notaries and their activities. Well, if a notary can do anything an act can do, then that means I'm my own appeal court and I undo the notary of that notary. So, okay. I mean, I'm just trying to follow the logic train all the way through. It's like, as long as notaries can do anything, one thing notaries can do is, hear appeals apparently, which means that I'm going to overturn the other. Okay.
Yep.
Yeah. Just trying to apply logic. I will subsequently comment on the well-established general authority of a superior court of inherent jurisdiction and how this defeats the army category. That too. Religion or religious belief trumps the court. Religion is a common basis for a claim a court cannot act. While the precise manner in which a religion or a religious principle are invoked are many, all these schemes appear to flow from a common rationale. There's some form of religious authority or law that trumps the court of Canada. Well, in the religious domain, I suppose that's true. And there are religious courts that hear religious matters for religious reasons, that issue religious judgments that the courts in some respects can't touch, because to the extent they deal with religious matters, they are religious matters. The most common way I know of this coming up, incidentally, would be like for concepts like religious divorce or religious annulment versus the civil concept, right? Because
Right.
you can get married by a church or get married by the state or get married by both. And to some extent, those relationships could be disparate. And the state can grant you a divorce, but not necessarily your religion. And then you get into the hardcore Orthodox, and we start talking about gets and stuff like that. But that's another discussion for another time. Okay. Some litigants claim immunity on the basis of religion, like Mr. Meads, say they're only subject to something like God's law or biblical principles. Often these religion beliefs conveniently excuse a litigant from some onerous obligation, such as paying taxes or obtaining a driver's license, motor vehicle registration, and automobile insurance. Members of the Edmonton church area, there's that Ian Runkle again, members of the Edmonton area Church of the Ecumenical Redemption International, the group headed by Minister Bellinger, well, maybe he used to be the head, but we all know who the real head is, right? Claim that the possession and use of marijuana is authorized by the King James Bible. We read this section in the King James Bible. We were not particularly convinced it spoke to marijuana. Claim their possession and use of marijuana is authorized by the Bible, and therefore state and courts have no authority to restrict these activities. Well, good news to those people. It's legal in Canada now, so have fun.
And New Jersey.
And New Jersey. And, you know, if the fates are kind, soon to be changed in schedule under federal law, because the whole thing is a little dumb. So that would be nice. Yeah. They said the Biden said he was going to reschedule. He might reschedule to only Schedule 2, but literally anything's an improvement.
I think that's what I heard too, that he's going to move it from Schedule 1 to Schedule 2. So, yeah,
anything's
better than nothing.
Anything's an improvement. Yeah. There are Schedule 2 medications that people get prescribed and pick up from pharmacies. I'm trying to think. I think there's some ADHD drugs that are there. Like, I'm trying to think, like Adderall. Isn't Adderall like Schedule 2 because Adderall is basically speed? Yeah.
It's an amphetamine.
So Adderall, for example, is a Schedule 2 drug. People use Adderall. They get it from pharmacies. So, yeah. Briefly, religious activities and association is protected under the rights. However, Canadian courts recognize that this restricted right is subordinate to reasonable limits prescribed by law, as can justifiably be demonstrated in a free society. Yeah, that's Canada for you. They suck. The Supreme Court of Canada has been explicit that religious beliefs do not trump the right of government to organize and regulate Canadian society. Yeah, your religious liberty rights are not as expansive in Canada as they are in the United States. God bless the United States of America. But even in America, which might have the greatest religious liberty of any country in the world, to be quite honest, even in America, your religious rights, they're not completely absolute, because if they were, that'd be really dumb. The litigants usually do not frame their religious arguments in a charter's context, but which would be the appropriate venue for them, rather than a bald declaration of religious-based immunity. The litigants also have seized on the preamble to the Constitution Act, which reads, "Whereas Canada is founded on principles that recognize the supremacy of God and rule of law." This passage has been the subject of occasional judicial commentary, most simply because various litigants have argued the preamble makes any of Canadians' laws subject to the supremacy of God. This proposition is expertly dismantled and dismissed by Justice Molden in a case where he concludes, the preamble to the Charter provides an important element in defining Canada, but recognition of the supremacy of God emplaced in the supreme law of Canada goes no further than this. It prevents the Canadian state from becoming officially atheistic. It does not make Canada a theocracy because of the enormity of beliefs of how God, apparently the very same deity for Jews, Christians, and Muslims, wants people to behave generally and worship in particular. The preamble recognizes the supremacy of God, then, does not prevent Canada from being a secular state. Well, it kind of does a little bit in my view, but okay. I mean, you're at least if you're not a theocracy, then you're a theocracy? You're a deist? So you're a theocracy?
Yeah.
So okay.
I mean, it did the same element as the preamble. Was it the Declaration? Recognize the Creator.
Yeah.
It's not necessarily.
Yeah. Other litigants claim that legislation, common law, and court principles and procedures are subject to God's law or divinely ordained rules or principles have been uniformly rejected. In some case, this declaration took the form of a colorfully named constructive notice of child of God status. Okay. Justice Garson concluded this was not the basis to remove her from the trial, as the litigant has not accepted my jurisdiction in this matter. The same approach was unsuccessful at defeating the Law Society of British Columbia's authority to regulate the law practice. I hadn't thought about that one. I haven't thought about saying I'm giving a notice of the child of God, and therefore the Texas bar can't regulate me. That's a neat one.
It's another way of saying. It's a more how do you say it? More flowery way of saying I have a God-given right to practice law, and you can't tell me I can't. Basically.
Yeah. Similarly, there's no God-given right to travel on public roads that trumps legislation. It would be a little bit hard to be a God-given right to travel on roads because, there were a time when there weren't roads. So, yeah. Justice Haraff concludes that debtors claim to be washed to debt by the blood of our Lord Jesus Christ, which was redeemed of all debt. That's a nice one. I like that. I like that one. Mr. Meads advanced an ill-formed argument that God's law, or the maximus of law, is the law which he chooses to apply in his proceedings. There is, of course, no basis for the demand. In any case, that would not defeat or restrict the authority of this court. The same would be true of any arguments this court's authority is subject to any other religious perspective or prescription. How fun and exciting. Let me read a few super chats that have come in along the way. Let's see. Sarah Silverman says, "Hey Kurt, Canadian here. Question: why are you studying Canadian law? Never see that from you." I'm reviewing this case because it's one of the best treatments of sovereign citizens that's ever been put into a court decision, and so it discusses a lot of the themes that we see in our own case. So trying to explain sovereign citizens like this case is a pretty good mechanism for it because, the same sort of things are experienced in American law. So the nature of the exact argument somewhat varies, although not that much. So yeah, that's why I'm covering this case. Helen says, "Are you allowed to have a cell phone in prison?" Not to the best of my knowledge. I've never been, but I'm not aware of any prison that allows you to have a cell phone. That'd be pretty weird. I mean, if you're a prisoner, to be sure. If you're not a prisoner, I don't know what the rules are. Aaron Morgan says, "Love your work, Kurt. Artie too." Excellent. Peter says, "I suspect this is going to be my second favorite Uncivil stream to re-listen to later, right after the St. Benitez decision. I'm well past 10 listens on that one." Jojo6178 says, "I think Brooks was a soft sit wannabe." Yeah, he just heard some buzz phrases, and for lack of anything else to do. I think the truth is fairly simple. I think that Brooks is a guy who used to being controlling and being abusive to people. And I think you saw that in his questioning of his ex-girlfriend. And that's like just one more ability for him to have some sort of power over her. And he likes the power and control. And it's just some mechanism, any mechanisms that gives him any slight of control. And I think, I don't really think it's much more complicated than that. And if he knew more, he'd probably use it more expertly, but it's just something that came along his way, and it's like just a way for him to exert his power. Ron White said, "Don't buy it yet, Kurt. I have it in my cart for you. Where to find my address?" On my about page, on my channel page, is on my about page, has my address. Ron White says, "I'm pretty sure I saw Brooks had pictures he wanted to put in evidence and told Judge Darrow they were notarized. Therefore, she had to accept them as an exhibit."
Wait, the pictures of the children? I'll have to go back to look at that.
I'm not sure which pictures they're referring to. I don't remember that particular portion of testimony, but yeah. And then do you remember that like whole thing? Well, where else could it come from? Where else could it come from Brooks?
Mm-hmm. Yeah.
And then the state basically, after that was all over, by the way, we'd like to make an offer of proof about all this because the letter, in fact, came from his mom, or like and stuff like that. It's like, here's where it actually came from. And by the way, had she been called to the stand, here's what she would have said. She's never sent a letter to Mr. Brooks.
Mm-hmm.
In fact, Mr. Brooks has tried to call her like 60 times. And she's never once taken the call. I'm like, where else could it come from? Well, we know where it came from. Let's just put that on the record. Like, yeah. Monday is the day when we're going to schedule the sentencing. I hope it's going to come real soon. I hope it's going to be like, we'll squeeze it in somewhere. I hope it's going to be real soon. And then he can be sent off to prison. And then we never have to hear about him ever again.
Yeah, I would relish in that. As fun, I'm using them big quotes, as it has been covering this trial, I'm ready for it to be done with.
And when he gets to prison, when he goes to prison, I think I will send him a letter, and to Daryl Brooks in quotation marks, and then the entire letter will just read, "Dear Daryl, get wrecked."
And the only thing I'll have is I'll set up a Lexus alert for Daryl Brooks, just in case he files his eventual appeal, and I'll get to read the court's denial in a live stream. So
yeah, we'll see if his court-appointed counsel files a I can't do this brief. So we covered that case recently on my channel. I want to say Allen, but I know that's wrong. I'm just trying to remember what it's called. It's called
it's like an Allen petition or Allen motion or something like that.
No, it's not Allen. It's a different name. It's trying to remember because we covered it on my channel like very recently and I can't remember. But whatever. Anyways, my chat will remind me in about 5 seconds because one of the best ways to find out a piece of information is just being wrong on the internet. A very common demand that a judge produce some kind of...
That's what it was.
Anders, thank you. See, there you go. How easy was that? I told you.
It.
It's great. All right. A very common demand is the judge provides some indication of valid authority. Commonly, that demand is for documentation, such as certification of appointment or a copy of the oath of office. In Alberta, in some case, a representative added the following postscript to a submission. If you had jurisdiction on June the 7th, even under the Admiralty Court, you must have taken an oath. Can you provide me a copy of your oath, like other professions must provide, to show copies posted of their certification that are legitimate and not imposters? It would be appreciated since it's demanded in the provincial code. Okay. Curiously, these litigants do not appear to be aware that judicial appointments are published as the order in council. Yeah, there's it's public record. If you really want a copy, right? It's well established that a judge or court author is presumptively authorized to act as they do, and rather that the litigant who claims some deficiency or bias must prove that deficiency. Justice Barrow explained this in this manner. His position appears to be that simply announcing the challenge to the authority of the judge or crown to occupy the position is sufficient. It's not. There must be some evidence that casts doubt of what appears to be regular. There is no evidence to doubt the status. Thus, this ground of appeal, to the extent it relates to the status, has no merit. Yeah, it's up to you to prove it, not the other way around. A litigant sometimes demands the judge swear various oath and follows with an allegation. The failure to do so defeats the court's authority. Apparently this has happened in some case. Justice McCling's response was succinct. Reverend Ballinger demands I take an oath for his use that acknowledges the supremacy of God and the charter rights. I have declined this opportunity. Nice. Other report demands to demonstrate judicial authority include, are you a public servant? We heard that a lot in the Brooks case. This court state its jurisdiction. We heard a lot of that in the case. A court disprove its acts in color of law. We even heard that in the case.
Yep.
This is why we'd be covering the Canadian case, because like this is just a good layout of all this shit. We've seen it all before. Other litigants. Go ahead.
No, just to reiterate, notwithstanding that this is talking about OPCAs in Canada, this I would say a good chunk, if not the majority of it, had its origin in the U.S. It just melted over into Canada over the years.
Yeah, like many great American exports. Other litigants claim judicial bias, influence, or conspiracy. We heard that. However, a litigant who advances that kind of claim has an obligation to prove. The Court of Appeals, I mean, if I'm the Court of Appeals on the Brooks case, I just want to write judgment affirmed. I cannot be bothered to write anything else. Maybe judgment affirmed, enjoy jail. A further alleged defect category involves some formal aspect of the court or its activities. For example, Henry has argued whether a judge is or is not gowned affects the judge's jurisdiction. The judge's choice of wardrobe affects the judge's jurisdiction.
Was he or was he not wearing the wig? If not, all his orders are null and void. There it is.
A parallel concept is advanced by Edmonton area guru Bellinger, who puts special significance on the edition of the Bible present in the courtroom, and the witness holds when swearing their evidence. Bellinger claims that only a King James Bible and perhaps a specific edition can serve that role. Of course, that's nonsense. It's neither literature or common law that makes this requirement. Incidentally, you don't have to swear an oath. You can affirm. At least in U.S. law, I would imagine it's the same in Canada. You don't have to swear an oath on a Bible or anything else. You can simply affirm. Thank you, the Quakers. A parallel concept is advanced by Edmonton area guru Bellinger, who puts a special significance on the addition of the Bible. Okay, we read that one. As for any common law argument, there's no question that specific choice of Bible or other sacred text present in the courtroom falls within the jurisdiction of the court to manage its proceedings and procedures. A recent High Ontario case, and a lot of courts don't use the Bible to swear in. You know, especially these days. I think it's probably more rare than not. I mean, I couldn't swear it universally, but I think it's falling out of fashion for sure, because, you know, there's no reason to do it in particular. As for common law requirement, there's no question a specific choice of Bible is in the court. As the recent Ontario case reports a bizarre defective court authority concept. The trial adjourned a hearing and exited the courtroom in response to disruptive conduct by the litigant. That litigant, a self-declared sovereign man, said that the judge has left the court, has abandoned the court. I, as a sovereign citizen, claim authority and dismiss the matter.
Or the judge has abandoned ship, and I am now captain of this vessel and have dismissed the matter.
The transcripts indicates the clerk responded, no, you cannot. The litigant then left the courtroom. The proceeding continued later after first the judge and litigant returned. On appeal, Justice Coates concluded the adjournment did not end the matter in the litigant's favor or permit them to seize control and proceed.
I mean, honestly, the fact that, you know, as an appellate judge, you do I really have to say this? Do I really have to put this on paper? No, the fact that the fact that you declared yourself sovereign did not mean that you won the case.
The state is defective. A more global attack on the authority of the state has also been advanced as a defect that allegedly defeats jurisdiction. A good example of this variant, of this particular argument, is that no post-1931 Governor General has a valid appointment because of a defect of the 1931 Statute of Westminster. Oh, that sounds like some bullshit. That defect allegedly cascaded to invalidate all post-1931 governmental legislation and action, including the operation of the courts and appointment of the judges.
That and the next paragraph. Actually, go ahead and read the next paragraph, and I'll chime in.
Excellent. Lindsay has also alleged that defect in Queen Elizabeth II's coronation oath subverts all government and judicial authority, as the Queen is constitutionally and contractually to uphold and enforce the laws of God as they're set out in the King James Version of the Holy Bible, which are the supreme source of law. This allegedly collapses state and judicial authority. Unsurprisingly, the British Columbia Court of Appeals has concluded the argument has no basis.
So there's an American, I would say the closest American analog that I've heard from sovereign citizens has to do with the Civil War. that allegedly in 1861 or I think it's 1861, when the Civil War broke out, like Congress adjourned without a quorum or something to that effect, and therefore any because of that defect, any and all laws passed by Congress since then are null and void. That is the American equivalent or American analog I can think of to that. That some minor defect completely negates everything.
If they adjourned without a quorum, which is what you do, then why would they not be able to reconstitute themselves once they had a quorum?
You're asking the wrong person. I'm the wrong person to ask that question.
I don't understand. Okay. I'm trying to apply logic to the situation again. It's a mistake. It's a mistake. Nothing makes any sense, and I don't like it. What was I talking about? Okay. Anyways, all defective court schemes face two issues: a rebuttable presumption the court and judge are authorized, and the intrinsic authority of the courts of inherent jurisdiction. Yeah, incidentally, in Wisconsin, as was pointed out, the circuit courts are actually provided for by the Constitution of Wisconsin itself. They're not even statutory. They're constitutional. They're in the Constitution of Wisconsin. So, there's that. Perhaps the strangest is reported by Joel Silversmith is the missing 13th Amendment. Oh, the Titles of Nobility Amendment? Yeah, we discussed that a little bit before. The paper documents how certain United States litigants alleged that a secret and lost constitutional amendment subverts the authorities and judges by stripping their status as American citizens because they are petty British nobility esquires. That's hilarious.
British accredited registry. You know it.
I don't know it because...
well, I mean, I did miss that part when I finished law school and took the bar.
Yeah.
I only remember swearing an oath to uphold the New Jersey, New York, and U.S. constitutions. I don't remember swearing fealty to the Queen. So
I similarly do not. I remember swearing an oath to uphold the Constitution of the United States and the state, and conduct myself according to the laws of the United States and the state. Again, do not remember the swearing the oath to the Queen /King /UK. Missed that memo. It's a registry so secret, even I don't know about it. Okay, we're going to learn about the magic hats. Excellent. For this section, I require my magic hat. Excellent.
Nice.
Another branch of the immunity category flows from the argument that a person has some status or has undertaken some steps that renders them immune to court action. I've given this category the name magic hats to capture the manner in which gurus and litigants approach these arguments. They freely wear, remove, and switch magic hats as need be. Many of these schemes are a combination or succession of magic hats. The manner in which magic hat schemes are presented is sometimes entirely arbitrary. A litigant need only say, "I'm a sovereign man," or "I'm a freeman on the land," and then are allegedly rendered immune to state and court action, all without any other further effort, explanation, or rationale. Some litigants go further. There is a report of a litigant who filed an affidavit of non-participation in commercial activity that announced, "I'm immune from the jurisdiction of any court of Canada." Sometimes a magic hat is accompanied by a theoretical context to explain the operation of the magic hat. Mr. Meads, for example, has explained his immunity to state and court action by his choice to be subject to God's law, the maximus of law, which applies to him as he is a living flesh and blood sentient man. In these reasons, I will survey and categorize the plethora of magic hats that are reported in Canadian jurisprudence that have also been identified by this court. There are three special categories of magic hat schemes that will be reviewed separately because of their complex nature and due to the variations in which they're often expressed. That no legal obligation can be enforced on the litigant without his or her agreement. A single person has two legal aspects or can be split into two legal entities. And a litigant can unilaterally bind the state a stat actor or court or other persons with his foisted agreement. I'll first examine and catalog the simpler magic hats. There are not so much separate and distinct categories, but instead potentially useful groups for analysis and review. Sometimes a particular magic hat will fall into more than one group, depending on how it's expressed or worn. Well, I wear my magic hat with style. Many of the litigants argue that they cannot be targets of state sanction or legal obligation because they're not subject to that kind of obligation. These arguments are often bizarre. For example, Warman, then represented by Lindsay unsuccessfully, argued the criminal code only applies to fictitious persons and not a sovereign flesh and blood living man. That was rejected without any kind of legal, historical, or constitutional foundation whatsoever. A similar argument that only corporations and not human beings are subject to Canadian law was addressed and rejected in Waterloo, where the litigant claimed the criminal code only applies to corporate and fictitious persons, such as Artie, which is both a corporation and a fictitious person.
Absolutely.
In the case of Martin, Dexter interpreted the law to indicate that all Canadian law only applies to entities that advance government policy, programs, or functions. That was rejected. Another school of the exempt category claims the litigant is immune because of an association with some foreign nation state or aboriginal affiliation. These jurisdictions are often imaginary. This concept is popular with the American litigants. For example, the judge's office occasionally receives complex documents from persons who claim to be citizens of Texas. Don't besmirch my state. Don't bring me into this. Also, incidentally, for what it's worth, I am in fact a citizen of Texas. So, for whatever value it has.
Well,
it's the 14th Amendment, Artie. It says I'm a citizen of Texas.
Right. But Texas is not an independent nation state, though.
There's that. Yes. Okay. Anyways, carrying on. An independent nation state. On that basis, they claim immunity from traffic tickets issued by Alberta. That doesn't even make sense. The United States, which is in fact an independent nation state, doesn't make you exempt from the traffic tickets of Alberta either.
Yeah, even if Texas was an independent nation state, that doesn't mean you can break the laws of another nation state. Yeah.
On that basis, they claim immunity for these tickets. Persons in this category will manufacture their own national identification license plates. Wilmingham attempted this approach, but also claimed to be ambassador of the nation of Texas. Kick-ass.
I know exactly who Winningham is. His YouTube channel is Sovereign Living, and he, in particular, he really, really does not like lawyers. Like, he has a raging hate for lawyers, in particular. But
you don't think he'll agree to be? You don't think he'll agree to be on my channel?
No, unfortunately not.
But I want to have an audience with the ambassador of the nation of Texas.
Republic of Texas, though, specifically.
No, apparently nation of Texas. That's what it says.
Oh, it does say nation of Texas. I guess he changed his moniker from that Canada case, but he's posted videos of Republic of Texas assembly meetings on his channel before.
Excellent.
So,
can I go to these meetings?
Maybe, probably.
They should be open to the public, right?
I know. True.
Mm-hmm. Aboriginal status, real or fictional, is another basis that allegedly proves immunity to court action or an income tax obligation. The court has received correspondence from the tacit supreme in law court of the sovereign nation's embassies of Mother Earth. I didn't know Mother Earth had embassies. This is interesting. Which appears to combine aboriginal status and claim nation status as a basis for immunity. Artie.
Yes.
You were saying, sir.
Oh, I was just referring to Mother Earth could have also been Gaia, but I mean, I've heard a lot of, New Age folks refer to that, but this is an example of a mixture of the Aboriginal and Moorish groups, which he also talks about later on. Oh, right there. I have a Yamasee Moors right there.
Another interesting variation on the aboriginal immunity concept is advanced by Henry as Chief Nanya Sabu L of Atsikhata Nation of Yamasee Moors. Henry not only claims to be the head of an independent nation state and aboriginal community, but that his tribe owns Canada. He now demands rent. Henry has at times filed bizarre and elaborate documents with his court that appear intended to assert and force ownership. I agree with Justice Sanderman's succinct evaluation of Henry's claims as total gibberish. Similarly, Moorish affiliation, in this case membership in the Moorish Divine and National Movement of North America, which also has a different name I learned earlier, but I've since forgotten it because I couldn't be bothered to remember, did not provide inherent jurisdiction or capacity to trump Canadian legislation, administrative tribunals, or the courts. Henry has also worn a literal magic hat. Henry's a man after my own heart, man.
Oh, there it is.
In the Alberta Court of Queen's Bench, Henry versus Starwood, before Justice Shelley, Henry appeared wearing what's best described as ceremonial garb with a robe and red fez that he indicated had special significance. Subsequently, Henry has appeared in chambers what appears to be wearing a lawyer's robes. It seems that Moorish law advocates place special weight on court dress, particularly since Henry appealed Justice Shelley's finding in part on the basis that he had garbed himself in a manner appropriate for the occasion, but she had not. Drama over fashion. Unsurprisingly, the detaxers have developed their own exempt arguments as why they should not have to pay tax. I've previously commented on the thoroughly discredited argument that only corporations are taxpayers. Justice Myers put as well as anyone in his trial decision. The theory not only does not bear any legal logic, but it also fails to accord with common sense. It is a failed attempt at word magic and has no validity. Pretty much.
I just briefly want to say I gotta head out and go get some dinner, but
okay.
I want to thank you for having me on. It's definitely a wealth of information in Meads versus Meads. It's definitely worth a read if you really want to go into the nitty gritty of sovereign citizens.
Yeah.
But yeah, thanks a lot for having me. Can I do a quick plug?
You can absolutely pimp your channel, of course. Let me put you up a solo.
No, it's just tonight at 9 o'clock. I'll be on at 9 Eastern, going through the premiere of the Kim Blandino saga. He is facing a probation revocation hearing. He is not a sovereign citizen, but he is most definitely a vexatious litigant. And it's going to be a very, very interesting hearing because I was able to get a sneak peek from our Nevada judges, and it's going to be very fun. So please, if you want, tune in there. But thank you again, Kurt. Absolutely. Would love to join in another time, man. And we'd love to have you on mine as well.
That'll be fun sometime. And
sure.
What videos do you have coming up? Do you have anything coming up in particular you'd like to talk about other than what you just mentioned?
Ooh. I've been working on doing a deep dive on a particular guru named David Straight, but I still need work on it. But right now I don't have anything sovereign citizen related in the woodwork. But okay. I'll definitely keep you in the loop when I get something together.
Well, you can always go through the filings of Darrell Brooks in detail. I'm sure there's content there for days.
I mean, again, I'm just so sick of it. I'm sick of that name.
I feel you.
You know what I mean? So.
All right. Well, I'll let you go. Please remember to check out my guest, Artie Corporate Fiction, on his YouTube channel. If you're into that sovereign citizen stuff, he's the man for that. And till later, thanks, Artie, for dropping by. We'll see you later.
Thank you.
All right. Bye-bye.
See ya. Bye-bye.
Great. All right. So let's read some super chats now. Let's see. Ron White gave some money to say, I'm pretty sure I saw Brooks had pictures he wanted to put in evidence. and told Judge Darrow they were notarized and therefore had to accept them. Ron White said they were pictures of his girlfriend. He wanted to show she was a bad mother, and then said, correction, Kurt, they were pictures of his kid. Yeah, I know there was pictures of his kids. I don't know whether or not they were notarized or not, so I don't know if those were the photographs being referred to. I don't remember him saying that those particular photographs were notarized, which I don't think they were, just based on the timing of when they were received, because he would have been in prison when he received them, based on my understanding of the timeline. So I don't think they could have been notarized, but, you know, maybe I missed something, but I appreciate it anyway. Let's see. How long have we been here? 2 hours, 24 minutes? Okay. How are we going to have to do this as a part 2? We might have to do this as a part 2. Let me see how much. Yeah, because we're like nowhere close. We may or may not do it part 2. Let's finish up this section. Let's finish up the section. It's a couple pages more, and then we'll end it, and we may or may not do more in the future, depending. So we'll do another like 5 pages of this, and then we'll end for the day, and reevaluate if we want to do more. Let's see, where was I? Okay. All right, great. All right, let's cover the next. So we got about 5 or 6 more pages of this until this section is concluded. And then we'll end the stream for the day. And don't forget to check out Rob with Law and Lumber for Friday Night Frenzy. I'm going to ask to join Rob tonight. I don't think I'm going to do a stream after Rob. But I think I'm going to try to join Rob for Friday Night Frenzy, because that sounds fun. So I'm going to take a break and then do that. Anyways, let's read the next 5 pages and we'll wrap it up for today. Unsurprisingly, okay, where was I? Okay, we read that section. All right, we read that section. Okay. Obligation to adhere to motor vehicle licensing, registration, and insurance seems to have spawned considerable litigant activity. One apparently common argument is that the litigant is not subject to these requirements because legislation only applies to either commercial vehicles or vehicles operated by corporations. Similarly, courts have rejected arguments the driver in the motor vehicle legislation is restricted to obsolete interpretations of that definitions. Persons who have direct horse-drawn vehicles or persons whose profession involves moving livestock. This case reports quite common strategy of citing only historic rather than current references. The failure of this and related arguments was summarized by Justice Stinson in a manner, saying it may well be the defendant wishes not to be governed by the traffic law or any other statute for that matter, and may offend their personal beliefs, which they're obviously entitled to have. But if she does not wish to be subject to the law, the solution is quite clear. They need only not drive. The law, whether the defendant likes it or not, governs conduct when they are the driver of the vehicle. I declare myself immune. Great. Another common variation on the immunity category is a universal declaration of some form may defeat state and court authority. This concept is closely associated with sovereign man and free man on the land movements, but also emerges in other contexts. The immunity declaration concept is interwoven into general obligation requires obligation strategy. Of course, it is indeed possible to cease to be governed by Canadian law. One only need leave Canada and break formal ties with the jurisdiction. However, the immunity by declaration school claims a person can live in Canada, but without any obligation or responsibility as a consequence of some special status, which has various names such as sovereign man or freeman on the land. This immunity by declaration group often draws arbitrary lines between statuses and common law and says they're subject to common law, but not legislation. Mr. Meads appears to have adopted that kind of distinction. Often immunity is based nothing more than a bald allegation of some magic hat status that flows from a name-based category. Examples include to be a freeman on the land, a freeman and natural person, a freeman on the land and unilaterally defining relationships and obligations with others by treaty, a free will full liability person under Anglo-Saxon common law, a sovereign man or sovereign citizen, or a nation state. Attempts to unilaterally declare immunity to income tax obligation are not uncommon. Similarly, in the case law, litigants have declared they've abandoned their social insurance number, social security number for Americans. In the case law, the claim of immunity was a consequence of declaration from the litigant, who would not enter into commercial activities, and therefore I'm immune from the jurisdiction of any court of Canada. I've been incorrectly identified. Another common claim is the litigant is not the person identified by litigation documents. This concept is usually linked to the double split person strategy, so the litigant will then explain they are some kind of representative, agent, trustee, or guardian for the litigation's actual target. There you go. That's Mr. Brooks for you. Given the obsessive focus of the movement for documentary and procedural formalities, real or imagined, it's unsurprising they've developed a wealth of arbitrarily related rules. For example, Canadian courts have evaluated and rejected the following nomenclature-related schemes. A person is not immune from court action if that person identifies himself by an entirely different name. For example, Mithlim Axwell instead of Casimir Chester Krishuk. Structuring a name in the format of first name dash middle name colon last name, for example, David dash Kevin colon Lindsay, does not mean that one is a separate person from David Kinsey Lindsay. David Kinsey Lindsay. Structuring a name in the formal first name of the family of last name, for example, John Donald of the family Sargent, does not mean that one is a separate person from John Donald Sargent. There's no legal distinction between a name in uppercase letters and lowercase letters and a name in all capital letters. No, there's not. You can spell your name any which way you want. There's no legal distinction between the variants. A claim that a person named in litigation is incorrectly identified by a war name or a nom de guerre is irrelevant. A name on all capitals is not a legal fiction and not different from flesh and blood bone man. Similarly, the litigants have demanded court documents such as informations and summons display their name in all capital letters. That presumably would then allow the litigant to claim that all capital names refers to someone else and thereby go free. Another immunity magic hat is the argument the litigant is only subject to different forms of law than that which would otherwise apply. This category is arguably a facet of the restricted court authority immunity group. It has become helpful at this point to make a few comments on the matter, of which litigants often use the term common law. Litigants often draw arbitrary lines between statutes and common law and say they're subject to common law, but not legislation. Of course, the opposite is in fact true. The common law is law developed incrementally by courts and subordinate to legislation. Statutes and regulations passed by national and provincial governments, the Constitutional Act provides for rules and principles that restrict the scope of legislation both by jurisdiction and right. I mean, that's as true in America as it is in Canada, right? The common law is subordinate to the statutory law. It's interpretations of the statutory law. It's not superseding the law. And it might change the understanding of the law, but that can always be changed by statute or by constitutional change, as the case may be, depending on what we're interpreting that day. Persons who claim to be only subject to common law do not appear to mean the current common law, but instead reference some historically, typically medieval form of law, quite often the Magna Carta, which is not relevant. An example provides how this might be expressed. Quoting, the above pose the fundamental reasons why I asked the court where this case could be tried under natural law for natural human person, an Anglo-Saxon common law court, a court without pretension, on a level floor without tiers, where the judge is not in administrative capacity, but that of a minister, not unlike clergy. It's a court where jurisdiction is declared with a flying Canadian flag on the building or within the designated courtroom. If Alberta does not have such a court, it's incumbent to be provided. Otherwise, it's contravening justice being served or seeming to be served because the court is operating outside the color of law. Dude, I think I lost brain cells just by reading that. Dude. Another example of the definition of common law is that certain litigants will claim not to require motor vehicle registrations, licenses, or license plates, because when they operate a motor vehicle, they are exercising their common law right to travel. This is how you know Darrell Brooks is not a real soft sit, because never once did he mention the right to travel, and that's just basic soft sit 101, man. I mean, come on. The courts have commonly rejected these arguments that the common law trumps legislation. Litigants also sometimes advance an ill-defined natural law, which has the sole authority over flesh and blood or natural human persons. Again, if you really want to be subject to the natural law, I'm not necessarily opposed to freeing you from the confines of this court and releasing you and allowing nature to take its course. That's really what you want. Really. Similarly, attempts to apply foreign law very often the UCC are without merit. Because we're in Canada, the UCC is not a thing. Reversing the more typical position, the court is restricted to Admiralty law jurisdiction. Some of the litigants have instead claimed they're subject solely to that kind of authority. Reversing the more typical position that the court is restricted to Admiralty law jurisdiction. He's not going to get an appeal heard. I mean, his appeal will be heard. It'll just be denied massively. His appeal will be heard. It'll just be unheard very fast. Because there's nothing to do. Lastly, the litigants and gurus tend to emphasize black law dictionaries as an authoritative source of Canadian law. One could say that this is their legal Bible. For example, Mr. Meads explains to me that as he's learning about law, he discovered the true meaning of the word license, an authorization to do something otherwise illegal. Well, I suppose that's one definition of the word license. Sure. This choice of Bible is peculiar, given that Black Law Dictionary is American rather than Canadian text. Of course, Canadian courts do make reference to Black Law Dictionary, but has nowhere near the same relevance, say, as Justice Coates' recent text, Words That Bind, words and phrases judicially considered by the Supreme Court of Canada and by the Judicial Committee of the Privy Council. Furthermore, it's not uncommon that the litigants will cite an obsolete older version of Black Law Dictionary. The second edition appears to be particularly popular, perhaps because now it's in the public domain. In court, a litigant may recite a passage from Black Law Dictionary and then demand to know how this is incorrect. I should get a copy of the second edition too, in print. Maybe I can consult a used bookstore. Maybe I can get myself a second edition Black Law Dictionary. That'd be good. In addition to a more recent one, that'd be kind of cool. I know it's available online, but it's just not the same. In addition, it's discussed below in relation to obligation requirements agreement, certain litigants attempt to frame interaction between individuals and the states as purely a form of contract, thus allegedly negating the effect of legislation. Mr. Meads has advanced this latter argument. He says his marriage with Miss Meads was a contract governed by God's law rather than the Divorce Act. Near legislation provides for an alternative scheme of law, so I reject. Conscientious objector. Non-religious belief has been advanced and rejected as a basis of immunity to state and court action. This has typically emerged in an income tax context. This is the chief theme of the Guru Lavinge, his thesis being that we should not be obligated to pay tax or presumably engage in any other activity that may promote thermonuclear war or mass murder. In the case law, Justice Proudfoot, great name, rejected a parallel argument. It appears that applicant and his friends are under the impression that because he is contesting the payment of taxes based on political belief rather than self-interest, he has somehow, I'll read these super chats because they caught my attention. Michael is a member for 23 months. TC gave $4.99 to say, I vote to end the stream with South Park Lane, Canada. Seems fitting. And Boliano of Ravenclaw gave $20 to say, you don't get enough love, and you make tons of great content, so I thought I'd send some your way. I appreciate that very, very much. P.S. My conscience is clear. It's probably the moment where even the last defender of DB said F you it was discussing. You know what's amazing about it is I listened to it live and I didn't hear him say it. I mean, I've obviously watched it back where it said it, but I don't know. Maybe my brain refused to process it because it was so dumb and stupid. that where he said my conscience is clear. But yeah, somehow like when he said it live, I missed it. Maybe I was talking over it, or maybe my brain rejected it or something, but dude, my conscience is clear? Really? Dude. You don't feel anything, you don't feel bad for the death and harm that you caused? Like even if he really feels like in his heart of heart of some levels, even if he really feels in some heart of hearts like he didn't intend to do it, or like it wasn't his goal, or you know, whatever, like that he doesn't feel bad about it, man. I mean, you know, if I did something that was an accident, if I did something that was an accident that resulted in someone's death, I'd feel pretty bad about it. I don't know about you guys, right? And the fact is, like, my conscience is clear. I'm like, geez, Lord, man. He also said he had no regrets. I did hear that part where he said no regrets. I did hear that part, which was also pretty stupid. Like, even if he really believes, even if it really was a pure accident, even if it really was a pure accident somehow, for which he had no legal liability, he wouldn't feel bad about it? Dude, I mean, you know, shit. I mean, come on. Also, it's God's plan. Yeah, that was a nice touch. I did hear that part too. Yeah, I did hear the part where he blamed God. I did catch that part. Yeah. Yeah. But thank you for saying I don't get enough love. I feel like, you know, and so, you know, I feel like I do okay for myself. You know, I've gained about 20,000 subscribers since the end of Johnny Depp. So we're growing slowly, but surely. We're at 115,000 subscribers. We're growing steadily. We seem to be making progress. This has also been the theme of this channel, like generally speaking. Obviously, there's been exceptions to those rules, right? So we've had these two huge spikes. We had a huge spike for Rittenhouse, and then we had a huge spike for Johnny Depp. But the overall trend, and if you go like look at Social Blade, or you go look at like these sites that keep track, and you kind of ignore the peaks, and you just kind of look at like what the trend line looks like between the peaks, it's a very, very steady line, right? So the growth of this channel has been historically a very stable, very sort of linear growth on the whole, right? And so that's fine. Like linear growth is fine, you know, and the occasional explosive growth is nice, because then, you know, if you continue to grow linearly after the explosive growth, then you're continuing on in nice form. But, you know, we're doing okay. We have 115,000 subscribers. We have, you know, a nice base of members. I hope more people will become members of the channel. You know, there's a lot of members, but it would be nice if there were more of them. You know, the amount of members we have, it's like under 1% of the channel is members. So, you know, it would be nice to have that grow more. You know, I'm not ungrateful for the 1% of you who are members, but it'd be nice to have that increase. It's one of the reasons I set the membership rate at 99 cents to hopefully make it very accessible to a wide swath of people. And so we'll continue to hope that that happens. But I'm really, really thankful for all of you here. And I'm also thankful that you allow me to try different things and experiment in different styles and do different kinds of coverage and, you know, do different things. I like to, you know, I have a niche. I have a niche of LawTube. I could even make it more nichey, right? You could make it even more niche and just be like, oh, I only want to do this kind of stuff and only want to do that kind of law. Like I've been resistant to make it even more nichey, like within the law context, like, oh, I'm only going to do Supreme Court cases. I'm only going to do Court of Appeals cases. Like, you know, I've been resistant. I'm only going to cover I'm only going to cover pop law. I'm only going to do this. So I've been resistant to that. I kind of want to keep it comparatively wider. But you know, things are going okay. Things are going okay. The channel's growing. I'm a lot happier doing this. That's nice. So, you know, it's all good. It's all good. And we continue trying things, and sometimes those things don't work. And we try new things like adding different colors in the background. And now I have my choice of colors because I added in the entire damn color wheel in buttons. I've got 12 buttons because I've got the entire damn color wheel now. So I think I'd like to do the rose triad. Let's do the rose triad. Rose is a nice color. Yay. Continuing on. That looks good. As an Australian, it's great to see a Yank in a real hat. Kick ass. Let's see. In some case, the Justice Proudfoot said, it appears the appellant and his friends are under the impression that because he is contesting the payment of taxes based on his political beliefs rather than self-interest, he is somehow or another entitled to immunity and cannot be prosecuted. That's a very interesting notion, but wholly devoid of merit. Similarly, a person that claims to be a tax protester also does not eliminate the obligations to pay income tax. Though perhaps disappointing to those who advance those theories, the fact remains of the issues that are policy and not ones the court can review. As a consequence, the courts have no authority to evaluate the political aspects that drive state processes such as taxation. This has been clearly expressed, in which has been stated, from a philosophical point of view, a case can no doubt be made that the impugned statute is cruel and inhuman, that's a travesty of recognized moral values, that constitutes an intrusion of the state not only to the bedrooms of the nation, as was said in our case, but into its piggy banks as well. One could also say that a good number of citizens share the applicant's view in these matters and would ring bells and dance in the streets if they're ever liberated from the unconscionable burden of taxation. The basic difficulty, however, is the position taken by applicant, although under the umbrella of judicial proceedings, is in fact a policy position over which courts and judges have no jurisdiction. Policies for legislature and judicial only for judges. Exactly so. Exactly so. He said he felt bad about it. He also said his conscience was clear, so if he said he felt bad about it, I'm disinclined to believe it. My conscience is clear is like, yeah. Okay. I think he's a monster. My position on Darrell Brooks is that he's a monster. Plain and simple. And when he gets sent to prison and the prison bars slam behind him, in his cell alone, I will be so happy. Tax-related magic hats. Now the sun is like peeking through and lighting my face. I'm very well illuminated by the sun because I left open the window because I wanted some sunlight. Detaxers and other litigants have advanced a wealth of magic hats that allegedly negate an obligation to pay income tax. Some of the relationship between state and individual that a person is immune from tax obligation because they're a shareholder in a jurisdiction or municipality has been rejected. Yeah. Well, if they're a shareholder, that kind of increases their obligation to pay tax in some ways because you have to pay your shareholder. Lol. A person can pay for their income taxes via prorated share of government property. It's pure unadulterated rubbish. An obligation to pay income tax arises only as a bargain in exchange for government programs, such as the Canadian pension plan. So if a person waives the claim, they also waive their requirement to pay income tax. The Canadian government has been financed by a secret arrangement that turns its citizens into corporations with military names has been rejected. I don't remember the military names one. That's new. Other allegedly relates to some kind of right. Collecting income tax is contrary to religious belief and thus offends the law in some way. Breaches the taxpayer's charter of rights. Is prohibited indirect tax as that authority is negated or displaced by authority. The redistributive effects of the income tax is contrary to charter and causes involuntary servitude. An unlimited right to demand information from the Canadian Revenue Agency and its employees. Income tax violates human rights and fundamental freedoms derived from the Canadian Bill of Rights. The notwithstanding clause is required to allow income tax to operate without breach of Canadian Bill of Rights. Some litigants allege that their income tax system is in some manner fraudulent. For example, the litigant in a case argued that filing an income tax return is committing fraud. The litigant said that the alleged national debt is a fraudulent scheme to extract funds from the International Monetary Fund. Unsurprisingly, there are a range of other income taxes related to formalities by case law. For example, de-taxers have argued that the state must provide fully amended certified copies of the Income Tax Act. They have also attempted to use a certified copy of legislation, here the Excise Tax Act, to prove compliance when that legislation was subsequently amended. I have a certified copy of the legislation. Yeah, but it's not the current copy. It's certified, but it's not current. Some perceived defect in the 1948 version of the Income Tax Act has been rejected as a basis to invalidate the current tax scheme. Other litigants claim that income tax has a restricted meaning. For example, it does not include compensation for work, does not include payment made under a contract for hire to a natural person. Wow, now the light's really coming in, and it's completely blowing out. It's completely blowing out my white balancing in ISO because it's fixed. And that's pretty hilarious. You go on camera. You can figure it out. Lol. Let's see. Damn, son. There's really no question the Canadian government is authorized to require individuals to pay income tax or other forms of indirect tax. Further, the consequences to a taxpayer who simply refuses to pay income tax are clear. It does not matter on what basis the claim is made. The refusal proves the willful intention to evade tax. Last are several magic hats that do not seem to involve into the convention category. There are several related to legislation. A litigant argued the presence or absence of formalities of how legislation was printed, such as coat of arms and queen printer notations, were significant. Another legislation-related argument is that a person cannot know the law unless legislation is fixed, certain, and accessible. The magic hat was that the law is amended is no longer knowable. That's just dumb on every possible level. Finally, in a different case, it was affirmed that comments on the litigant's attempt to use the common law petition of right, which has been abolished by the legislature. Okay, and then they're going to talk about the inherent authority of the provincial superior courts, which is decidedly not particularly relevant to our discussion. I'm not sure the degree to which any of this rest of this document is necessarily. I'm not sure the degree to which the focus on me. I'm not sure the degree to which any of this other commentary is necessarily relevant to our discussions or needs. But in any case, this has been an exciting review of sovereign citizen nonsense. And I think we've all learned about how the sovereign citizen nonsense comes in several different flavors and varieties. So it's been exciting and fun. Yeah. So yeah, it's been exciting and fun. As you can see, the sun is moving further and further into my direction. So for no other reason than the sun, I suppose I have to end the stream. But it's been a lot of fun. I'm going to plan to be on with Rob from Law and Lumber during his stream tonight, so you can look forward to that. And that'll be fun. Remember to do all the YouTubey things, like, comment, subscribe. I've been Uncivil Law. Until later, my friends, I hope all is well, Cheers, my friends, and goodbye.